Item number 1, OJC 2130 of 1999.
In the result, this writ petition stands dismissed, but in these circumstances, there shall be no order as to costs.
I agree. A short question, which the present intra-court appeal involves, is as to whether this case. Short question which is involved in the present intra-court appeal is as to whether penalty can be imposed in exercise of power under section 20 of the Right to Information Act on appellate authority has been defined on and appellate authority has been defined.
Yes,
Where is that?
in act it is not defined, my lord.
Oh.
Only higher rank
When you
officer.
are saying yes, then you are saying no.
No. My friend is saying yes. In act it is not defined. Only defined is only higher rank officer of that institution will hear the appeal.
My lord, I may
Next,
kindly
higher
draw the attention to Annexure 3. Annexure 3 is the authority where it is defined that who is the first appellate authority and who is the public information
In
officer.
act.
Annexure 3, page 24.
As far as the act is concerned, it is not defined, my lord. Section 19(1) appeal.
On an appellate authority by the Central Information Commission or the State Information Commission or not. And whether such penalty can be imposed only on the Central Public Information Officer bracketed CPIO or State Public Information Officer bracketed SPIO. Oh, stop. Section 20 of the Right to Information Act reads thus. Oh, stop. It is not in dispute that the appellant herein was not the public information officer. Full stop. The State Information Commission, Odisha, by an order dated penalty of rupees 15,000, comma, teaching her as an ex-public information officer. Full stop. Putting to challenge the said order of the State Information Commission, the State Information Commissioner, the appellant preferred a writ petition before this court, giving rise to WPC number 20436 of 2023, taking grounds on various grounds, including the ground that she was not given adequate opportunity to present her case before the State Information Commission. So stop. Next. A learned single judge of this court dismissed the writ application, taking into account writ application with a finding that notices were served upon the appellant, but she did not appear, and therefore appear before the State Information Commissioner, and therefore the order of the State Information Commissioner imposing penalty invoking Section 20 of the RTI Act could not be said to be in violation of principles of natural justice. Next. The said order dated so and so passed by the, what is the date? Where is the order?
It order
Dated
30.
6/7/2020.
Yes.
6/7.
6/7.
6/7/2023, passed by the learned single judge in WPC number 20436 of 2023, is under challenge in the present intra-court appeal. So stop. Learned counsel appearing on behalf of the appellant has heavily relied on the language used in section 20. Could you get that decision? Heavily relied on the language used in section 20 of the Act to contain that that an appellate authority, that the said provision does not stipulate imposition of penalty upon an appellate authority and such power to impose penalty can be exercised only against the CPI, against the Central Public Information Officer or the State Public Information Officer. So stop. Next. Learned counsel appearing on behalf of your opposite party number?
Respondent 2.
Respondent number 2 has submitted to defending the order passed by the learned single judge, has submitted that it is an admitted position that the appellant had failed to discharge her duty of appointing a public information officer.
Designated.
Huh?
Designated.
Designate a public information officer. Full stop. He submits that in such view of the matter, he has taken us to the definition of public authority falling under section 2 bracketed H of the Right to Information Act of the Act, RTI Act, and has submitted that the appellant, that since the appellant was holding the post of principal,
Headmistress.
headmistress of which school?
Of the Girls High School, Unit 4.
Girls High School?
Government Girls High School.
Government Girls High School.
Which place?
Bhubaneswar.
Bhubaneswar.
Unit 4, Bhubaneswar.
Bhubaneswar,
Unit 4.
comma, the penalty could be imposed upon her in exercise of the power under section 20 of the right to of the RTI Act. Full stop. He has. What else have you submitted? Anything else?
5 also I have submitted
5.
the obstruction of the information.
He has also drawn the court's attention to subsection 5 of section 5 of the RTI Act and has submitted that as the appellant that because of the appellant, the information could not be supplied to respondent number 2, comma, imposition of penalty by the State Commission is justified. Do you have any?
Sir, I may be permitted to submit one line. Annex 3, page now 24. The superior authority, by virtue of the order of the government, has specifically directed that as per the order number 4 of Honorable Information Commissioner and letter number dated 6/7/2011 of the Government of Orissa and School and Mass Education Department, headmaster, headmistress of all high schools of the state of Orissa and the senior most teachers are hereby appointed as the first information officer at the first appellate authority and PIO, means public information officer of the respective school. This is the order of the government. So there is no need of appointing the first, the senior most teacher.
Where is that?
It-
Which paragraph? Which
Annexure
page?
3,
Annexure 3.
page 24. So they are by this order, and this order has been concurred by the also by the
Senior
honorable
most
state-
teacher would be PIO and headmistress by default
will be the
would be
first
the
information,
first, first appellate authority.
That in that case, my lord, then
That
headmaster
is the
cannot say that there is no PIO. That is the, and my lord, one,
Mr. Counsel, please understand, she can be dismissed for her inaction. But whether penalty can be imposed is the only question.
yes, my lord. I just want to take 1 minute. Because in that letter itself, the government say name of the first appellate authority and PIO may please be intimated within 7 days.
One person cannot be in dual position.
No, my
You
lord.
have to read this way.
Correct.
Headmaster, headmistress, headmaster, headmistress shall be appellate authority of all high school and senior most teacher would be PIO.
My lord,
That way you have to read.
yes, my lord, automatically.
Purport of the letter is that.
Yes, my lord, automatically they will not, because I have brought out two documents of 2023, whereas headmaster of the school is acting as a PIO. There is a circular, but headmistress did not respond to that circular.
We will go by the documents which were before the Red Court and here.
the appellant.
No,
has
this
declared
document, my lord, this document is not
on
produced before the
31st
commission.
December 2022.
This document is not produced before the commission. So commission thinks that she is the PIO, as she did not appear or did not think anything
Therefore,
about this.
therefore,
that
Commissioner
circular.
was in error.
That is a letter.
I can brought the two documents where headmaster of the school are acting as PIO. Can I sublime it?
No.
Okay.
Yes, we have to.
My humble submission is, my lord. Entire pleadings, my lord, in fact, with regard to that act itself and provisions, my lord, I have no dispute to read that. Lordship is, my lord, my friends are correct. Also, lordship also perception. But it's an entire pleading, my lord, what happened? He never said that he is not the PIO, all these things are not there. He
Yes.
said that his opportunity was given to not given to me, so matter may be remitted back to the commission. That is the entire pleading in his writ application.
That
Despite
is different. We are on the question.
the
Why should?
penalty. With
We are
regard
on
to
the question whether this power can be
penalty.
exercised on the appellate.
That's how you
authority.
understood our scripts also.
Mr. Das,
That's-
if you go to one of the annexures,
Yes,
the noticee, she informed that her predecessor,
that's correct.
he was the senior most teacher.
That's,
After superannuation of the headmistress, she became headmistress
yes,
and she was called to explain. She gave the name of name of her predecessor,
appellant.
saying that information related to that period when this appellant was
That's correct.
the incumbent.
Correct.
So she was undoubtedly she was the appellate authority.
That's correct. But what happened? I verified the document. He remained only 1 day. After 1 day, he retired. So, with regard to information supply, my lord, appellant is not responsible for this.
And penal provisions are to be strictly construed.
That's correct.
Learned counsel, senior counsel.
BK Das, my lord, and my name is BK.
Vijay Kumar.
Senior counsel.
No.
Mr. B.K. Das, learned counsel representing the State Election Commission has does not dispute the legal position
Yes.
as evident from, as is evident from the language of section 20 of the RTI Act itself, that penalty cannot be imposed on the appellate authority in exercise of the said power. He, however, submits that no such plea was taken before the State Information Commissioner
Or in the writ application also.
or in the writ petition that the appellant was an appellate authority under the RTI Act. Stop. Next. Our attention has been drawn to a communication dated 16/7/2011 issued by the Office of the Inspector of Schools, Khurda, Circle Khurda, and which is addressed to the headmaster oblique headmistresses of all government aided. What is that?
Government or aided.
Slash aided.
Yes,
Government/aided/block grant high school, which reads as under, right from the subject to this may be treated as urgent. Page 24, annexure 3. Full stop. Next. Learned counsel appearing on behalf of respondent number 2 does not dispute the fact that being the headmistress of the school, she could not be treated to be the public information officer. Full stop. It is apparent from the said communication dated 16/7/2011 that it was the decision of the Government of Odisha School and Mass Communication Department that headmaster oblique headmistresses of such high schools shall be the first appellate authority and the senior most teacher as the senior most teacher, public information officer of the respective schools. Oh, stop. Next. It is that penal statute has to be read strictly. So stop. If on close reading of section 20 of the RTI, it can be easily discerned that the Central Information Commission or the State Information Commission has power to impose penalty on Central Public Information Officer or State Public Information Officer and no other authority under the Act. Full stop. The reliance placed by learned counsel for the respondent number 2 on subsection 5 of section 5 of the RTI Act is misconceived. Full stop. Subsection 5 of section 5 reads thus. Full stop. It is evident on reading of subsection 5 that subsection 4 and subsection 5. Central Public Information Officer or State Public Information Officer officer may seek assistance of any other officer, comma, in exercise of his function under subsection 4 of section 5, comma, as he or she considers it necessary for proper discharge of his or her duties. First stop. In the context of subsection 4, the subsection 5 provides that if any officer whose assistance has been sought under section 4 shall, that any officer whose assistance has been sought under subsection 4 shall be under obligation to render all assistance to the central public officer or the state public officer as the case may be, comma, seeking his or her assistance, and for the purpose of any contravention of the provisions of the Act, such officer shall be treated as central public officer or the state public officer as the case may be, comma, as the case may be. Full stop. Plain reading of subsection 4 and section 5 of the Act leads us to an irresistible conclusion that a person who is required by the CPIO or SPIO to render assistance for furnishing information under the Act, comma, such person shall be treated as CPIO or SPIO. First off, if he or she does not render assistance on demand by the public information officer under subsection 4, comma, he or she shall be treated to be public information officer. Since he or she shall be treated to be public information officer, comma, the penal provision under section 20 of the RTI Act may apply to him/her. First off, it is not the case, it is not the case here that any assistance was sought by the public information officer from the informant or from the appellant, and therefore she was to be treated as public information officer within the meaning of subsection 5 of section 5 of the Act. So stop. Next, we are of the definite opinion based on a reading of section 20, section 20 and section 5 bracketed 5 of the Act, that the state commission, that the state information commissioner could not have exercised power under section 20 of the Act by imposing penalty upon the appellant, as he was not, as state information, as the Central Information Commission or the State Information Commission
is not vested with such power. Stop. Next, accordingly, the writ petition is allowed. Accordingly, the order passed by the State Information Commission. What is that?
At Annex 5.
State Information Commission.
Annex 6.
Dated 24th April 2023.
Annexure 5.
Annex 5. In Annex 6.
Answer 6.
Annex 6.
Annexure
6.
Annex 6.
Accordingly, the order dated 24/4/2023 passed by the Odisha Information Commission, Bhubaneswar, passed by State Information Commissioner, Odisha Information Commission in complaint case number 96/2022 dated 24/4/2023 is hereby set aside. The writ petition WPC so and so is allowed. First off, the order passed by the learned single judge in WA number so and so is set aside. This appeal is allowed. No order has to cause.
My lord, can I apply for liberty? Because in this case, he said that I am the public first authority. Can I file a appeal against him, against or in the commission? Liberty may be granted.
Yes.
Cess admission item number 2.
One common judgment, impugned judgment is a common judgment, Annexure 15, but two writ petition. One writ petition filed by respondent number 428. In first writ appeal, your lordship 2432, it is the main writ appeal because, my lord, it is dependent on second. What is the result of the adult writ petition? That is dependent because, my lord, one first writ petition.
There are two writ petitions.
Two writ petition. Two
Open
writ,
judgment
a common judgment,
and two appeal.
two appeals.
Where is the second appeal?
Your lordship,
Where is the other appeal?
the other appeal 2433, the second. Second one is
Tagged up. Tagged up.
Yes, sir, Mr. Tag. Last occasion I mentioned, therefore, my lord, it has been tagged. So,
yeah,
your lordship,
we can hear.
your lordship. In first appeal, my lord, writ appeal, that one writ petition that arising out of WPC number 10241. That is, I am holding the first writ appeal, my lord. In that writ petition, private respondent number 428 filed a writ petition, my lord, before this honorable court challenging the order passed by the revisional court, my lord, under section 15B, filed by the present appellant that was allowed for correction of R1. That is on the ground that one cell deed was executed by ancestor of respondent number 428 in 1958, that I am in position, my lord, after my death, we are in position of that property peacefully, but mutation cannot.
Your appeal is barred by limitation.
Your lordship. That
So
is.
why has this matter been placed for admission?
Appeal, in past appeal, my lord, that one day delay has been condoned.
Delay has been cut.
Condoned in last occasion. Then, Your Lordship, then that writ petition, that revisional court's order has been challenged in this writ petition, WPC number 10, by private respondent. On the ground that the revision petition is barred by limitation because in 1950 that cell deed has been executed by ancestor of respondent number 428 in favor of the appellant's ancestor. So in 2018 that has been filed. But the mutation cannot be done, my lord, because it has there is no access to the that cell deed, that copy of cell deed to the present appellants, my lord. Therefore, after death of their father, that has come to light, the mutation was filed. When it was refused, then revision was filed. That is the ground that insufficient cause has been done. Therefore, my lord, revision was allowed. But your lordship, that single judge, your lordship may kindly see the impugned judgment, annexure 15, my lord. Your lordship, page 124.
Please come to paragraph 15 now.
Paragraph 15, my lord, that I am coming. Your lordship, before that, para 14 may I read, my lord, para 14. My lord, this court, above account submission of the contesting opposite party that there is an the allegation of fraud, it is thus contended when there is the allegation of fraud, initiation limitation doesn't matter. This court, looking into the pleading of the parties, finds there is no such pleading of the available in section 15 proceeding. This submission is a negative outright. This needs here to emphasize the role of authority exercising their power under section 15B of Odisha Survey and Settlement Act, looking to the adjudicating power with the authority under the provision of OSS Act, particularly section 15B of the Act. This is a simple proceeding to be decided only on the basis of available material. Further, here the commission performs just like a superior tahsildar and has to simply go by materials and without entering into any controversy, as it has no extensive power with authority like that under section 8A of Oiler Act and section 9 under section 36 and 37(2) of Odisha Consolidation, Holding and Fragmentation Act.
Oh. Reason appears to be plausible.
Your lordship.
The reason signed by the learned single judge appears.
Yes, my lord, that need not be required, my lord, till last may I permitted to read, then thereafter, my lord, till last, my lord, last para. In last para, kindly see that parties are seeking to approach to the appropriate adjudicating through the competent court of law. That means that title is not in the dispute, my lord. Only on the ground of limitation, it has been rejected that in 2017, Wheeler, the decision of this honorable court relying upon full bench decision, the reasonable period.
Appropriate adjudication through competent court of
Competent court.
That means-
Competent court of law. So,
including your title.
including, yes, including my title.
Right.
That is, my lord, that is the liberty is that is only option
So
for
that
me.
cannot be gone into under revisional jurisdiction under survey and settlement.
Yes.
So you have to establish your own right.
Own right.
Title.
Only, my lord, now, my lord, I have only option to that, my lord. Only, my lord, with the only observation that this impugned judgment will not stand as a bar in deciding my title, because title is not in my dispute, my lord. Only on the ground of limitation. There is no finding in this regard.
Which finding will prejudice your matter?
A finding, my lord, that if although there is no straitjacket formula, that what is reasonable period, but that is to be taking into consideration of the facts of the case in every case, my lord. But in relying upon that decision,
45 years.
relying on that decision,
45
because
years is not.
Rather than
reason-
single judge is given in liberty to approach the appropriate court. There is no adverse finding.
not given it is open, but
Okay.
that only observation that without prejudice my rights, because that only observation because at this stage there no.
After having argued the appeals at the and counsel connected by the impugned judgment and single judge, I tell that paragraph 14 paragraph 14 so having argued the appeals appellant and counsel for the appellant has submitted that that the appellants in the light of the observation made by the civil judge, the appellant shall approach a court of competent jurisdiction for deciding title. So, we have a submits that any observation in the present order may not, in the impugned order may not prejudice the appellant's case if any suit is filed before a competent court. So, in such view on the matters, we dispose of these appeals with this appeals. First of it goes without saying that if any title suit is filed, the same shall be decided on its suit of the suits. One suit
Lords.
is filed, the same shall be decided on its own merits as regards the title of the two appellants.
No, my lord, same. Appellants also
Appellant is
same. In second, in second writ appeal, my lord, that after the impugned order passed by the regional authority, I filed mutation. That mutation was allowed, and on next day it was recalled. That order was challenged. Yes, in view of this, that may be disposed.
We also make it clear that the parties make it clear that any observation made in the present order shall not prejudice the case of any of the parties.
Obliged.
Item number 3.
My lord,
This is the last order. Last order. We have to file an affidavit.
I was required to file an affidavit before my lords. I have received the instruction, my lord. The prayer, the 2013 that notification, we have decided, my lord, may I read it out? Government has also decided to omit the clauses A, B, C of Rule 15.1 and Rule 15.4 of the Odisha Forest Service Group B Recruitment and Condition of Service Rules 2013. The cabinet meeting has okayed it on 9/3, and we are under the process of coming out with a notification, madam. Madam, may kindly give us one adjournment so that
It may some more time. It may take more time because of some supervening
if
probability.
for my lord, just because in ODA, may I take, my lord, may kindly see. This is the
Kindly dispose of.
Second prayer, my lord. My read person second prayer. First prayer they have allowed, my lord, if they have amended it. If it is amended, first one. If it is made prospective, then second prayer, my lord, I will not make. Lordship grant, they will extend the relief to me, my lord, in view of the amendment. As per the second prayer, my lord. Because my training period is over now. Lordship will dispose it, they can consider.
After 4 weeks, as requested.
This is only cabinet memorandum. This is only cabinet memorandum.
309. So that, so after cabinet,
As requested on behalf of the state. This matter on 4 weeks.
Item number 4. Item 4.
No one appears. On behalf of the yes.
The virus of rehabilitation assistance
2020 rule.
2020.
The rule 6(9). That is.
No, he is challenging rule 2B and rule 3. What are these two rules? 2B is
Point system.
case
Point system. The Lordship can get it from page 27.
27. Deserving case.
Yes. Earlier it was not the point system. Subsequently in 2020 rule.
Evaluation process.
Yes.
And group this rule 3 is with regarding group D post.
Group D.
Irrationality, repugnance, aversion to fundamental objective. Undemocratic. Petitioner. This application is accordingly dismissed for default. Learned additional government advocate is present. First off. We have not gone into the merits of the petitioner's challenge to the validity of Rule 2 bracketed B and 3 of Odisha Service Rehabilitation Assistance Rule, 2020. Civil service. We have 2020. 23. All right. Well,
Any other case do you have you come across?
Yes, my lord. What has happened, my lord, in some
In the
cases,
similar line,
not
any other?
no, not in similar line. In one case, that Rule 6(9) was under challenge. The
That
virus,
is different. It
but
is not.
this is not challenge. Some cases were filed. Subsequently, it was withdrawn because of that Morayananda Sethi case.
Achha.
So all those cases which are
Because they
withdrawn,
were covered under
yes, ma'am,
1990.
they said that we are covered under
This is
99.
new case.
This is a new case. Many cases were filed.
yes, next.
Item number 5.
Sorry, item 4, I was, it is my item.
We have dismissed your case for default.
Sorry, sorry, my lord, the very crucial notification by virtue of this amendment notification 2020, in the state, not a single applicant has been rehabilitated under the rehabilitation scheme because Group C earlier scheme, both C and Group D were combined together. So, as per the amendment rule 2020, in clause 3, Group C is omitted. So presently, in every department, service providers, Group D posts are taken over by the service providers. So there is no post at all to accommodate the, to consider the grievance of the, my lord, the
Where are the rules?
my lord,
Where are the rules?
my lord. Page 28.
Page 20.
28, clause 3. Earlier, both C and Group D.
Just a minute. We have understood your.
Mind. Subject to provisions contained in rules, the deserving cases, one family member deceased government servant shall be appointed on compulsory.
Annexure 7.
Annexure 7, my lord. Page 28.
Yes.
Page 28, clause 3. Subject to provisions contained in these rules, in deserving cases, one family member of the deceased government servant shall be appointed on compassionate ground to Group D base level post only by the appointing authority of their deceased government servant, who shall not be claimed as a matter of right. So, my lord.
So this is group, they can be given only Group D post.
Group D. So,
And according to you, there is no Group D post.
there is no Group D post.
Where have you said?
My lord. So, the earlier, page 23.
Page 23.
3. In the, my lord, the pre-amended rule 7.
No, forget. Where have you said that there is no Group D post?
So, my lord, it is my averment is there because in every department, Group D, very few Group D posts.
We don't decide cases on the basis of our perception or something which you say orally. All right, you may have a valid point that they have decided to make appointments against Group D posts only, and there is no Group D post. So this is if that be so, then it is palpably illegal.
Yes, ma'am. So,
But where is that?
my lord, I have taken the averments, but the through RTI, I have.
RTI
No, my lord, in the practically after coming into force of the 2020 rule.
All right.
In this.
All right. Let us inquire from. Yes.
Your lordship, paragraph 11 of his writ petition.
No, but whether let us know whether the Group D posts are there or not.
Yes, my lord. He has admitted Group D posts are there. He has admitted Group D posts are there.
What you tell us?
Yes, Group D posts are there. Once one of
is considered under 2020 rule, he will be given appointment against a group D post. And your lordship may record my statement. If he qualifies, he will be given appointment. No, my lord, two things I have challenged here. In the base level, group C posts are abolished. What are the number of dependent children and number of unmarried daughters? So if somebody is left with unmarried daughters 10, 5, 6, 7, then he will get 12 marks. So in these contingencies, nobody is, my lord, given the 60% mark, the ceiling number. So the 2 point I have challenged. In the earlier rule, there was no ceiling, and only there was the combinedly group C and group D posts are there. So by only it remains in pen and paper. The present rule 2020 only remains in pen and paper. So my lord, we approach the government after coming into force 2020 rule. How many persons have been rehabilitated? So in the presently, my lord,
when you file a writ petition,
right,
or when you seek a relief based on facts, the determination is on different grounds, like it violates any provision when it is your right. But when you challenge statutory provision,
right,
you will have to say that this statute is contrary to any provision of the Constitution or any statutory provision. This appears to be rational.
no, my lord,
Your paragraph 11, as
11.
AGA points it out,
11, my lord.
is completely based on surmise.
Yes.
You read it, place it. It is only assumption. Page 9,
Yes, ma'am.
parallel.
It is a clear picture from the data of different establishment that group D posts are very few in every office. For example, in collectorate and directorate, more than 200 ministerial staff are there, whereas the group D post in such establishments are less than 20. So proportionately, the vacancies in group D post in a particular office will not provide employment to the applicants. So, my lord,
So there is no data available with you.
my lord,
There is no concrete data available
yes, my
with
lord.
you. You have
Lordship's query.
you have to
My
read to the
lordship's
books.
query. My lordship's query. We have, my lord, made an application also through the RT application to the General Ministry Department.
You have
The
briefing
architect
about
of
the
this,
bush, sir.
no, my lord, the architect of this the circular, General Ministry Department, after abolition of Group C post from in the new rule, and how many persons are given appointment under Group D? So, my lord, there is a circular in Finance Department.
Sir, you are not challenging an order. You are challenging a law. And you are referring to right to facts, right to information, and all those things.
My lord, lordships, my lord, I have a very good grievance, my lord, to satisfy lordship.
Yes, Mr. Counsel, why are you sitting on the bench? Why are you sitting there? Sit here somewhere. Take chair.
So, my lord, I have a very good grievance. So, my lord, to satisfy lordship. So, we'll, my lord, substantiate some important events and so, my lord, the documents to, my lord, to establish my claim.
Not do. Legislative provisions are not challenged like that. Sorry.
My lord, I pray, my lord, I pray because the documents might be available with...
Documents we will not see. You will have to show law. This provision is violative of any provision under the Constitution or any law.
Well, I'll satisfy. Only 1 week time, then
No,
I'll
1 week time. Tomorrow. They are already wasted.
by tomorrow, Monday.
No.
By tomorrow,
All right,
I'll remain
All
on
right, Monday.
accommodation.
As requested on behalf of the petitioner, this matter on Monday. This is not the way to challenge a rule.
Item number 5.
My lord.
Yes.
May I please, Your Lordships? Your Lordship, this is a non-compliance of order dated 23/3/2023, wherein Your Lordship, this Honorable Court had directed that the present to the present contender to examine the case and after hearing both the parties to pass a reasoned order not later than 1st June 2023. But yet, Your Lordship, there is no compliance of this order.
Lordship, grant me 2 weeks time only, Lord. Here I will obtain instruction from the Tahsildar, Lord.
So we will list all the contempt applications on one day.
Right, Your Lordship said so.
As requested on. We will take up all the contempt matters.
Good.
This matter we are just adjourning, but we will take up all contempt matters on particular day.
Right.
List this matter as requested on behalf of the AGA by AGA to seek instructions as regards compliance of this court's order dated 23/3/2023. List this matter.
Lords, call all those matters after 2-3 weeks, Lords. We'll see that all the orders are complied.
Every time you are saying this,
No, Lords. Your Lordship.
right from day one, you are saying that within 2 weeks, the order will be complied with.
No.
Every day. Now that observation was not only in respect of a particular case.
No, Your Lordship said that in respect to all contempts, Your
all
Lordship
contempt
said.
applications. Therefore, before someone is punished, you please ensure that the orders are complied with.
Right.
Yes.
Item number 6.
My Lordship, as a public interest matter, I am presenting this plea that Kodiyamali Hill of Lakshmi Block in Koraput district is completely community reserve forest, my Lord, where the mining operation of Odisha Mining Corporation has been going on since 2018 without the consent of Gram Sabha. But my Lord, the project proponents could able to obtain the final approval of forest clearance in the year 2017, very cleverly from the Ministry of Environment and Forest and Climate Change, by presenting the unworthy and fallacious grounds of proceeding which are not true and fact in nature, my Lord. On this regard, my Lord, I made representation to the collector Koraput for 4 times and MOFCC for 2 times. That is 20th February 2018, 14th November 2022, 18th January 2023, 7th August 2023, and 26th April 22 and 7th August 2023 respectively. But my Lord, neither the respondent took any action against the illegal mining operation nor replied my representation, my Lord. Hence, my Lord,
I have not been able to understand anything. This public interest litigation is for what?
sir, this is the interest of public matter, my Lord. Matter of public interest, where the Kodiyamali Community Reserve Forest, where thousands of people surrounding the hill, my Lord, are depending there on their.
Just a minute, just a minute.
Your representation is at Annex 20.
From 2018, my Lord.
No. Annex 20.
Yes, my Lord. Yes,
Are you pressing that?
my Lord.
Are you pressing your relief under that?
Yes, sir. Yes, my Lord.
So you require us to make some fishing and roving inquiry.
I am the direct authority person, my Lord, of that mining operation. and I am the inhabitants near to the Kadigamali hill, about 3 kilometers away. My village is situated, my lord.
Yes, what is your response?
No response. I didn't.
Oh, no,
I didn't
we are-
get it.
we want to
Mr.
know
Mahathir,
their-
कौन matter तक
My lord,
forest? Yeah, Mr. Pari, you are appearing forest and environment.
yes.
It's opposite part number 1, he's appearing.
Actually, what is his grievance?
Mining operation, just a minute, just a minute. Mining operation, as regard to this prayer is mining operation. It is the matter of state. As regard to this environment pollution permission is concerned, what some representation I have seen page 103, annexure 20, he has submitted the representation to the complaint to the Secretary, Ministry of Environment, Forest and Climate Changes. In this regard, I don't have any instruction. Let's keep it. Maybe I will take the instruction, but this notification, what they have cited upon, that is annexure, annexure 5, page 45.
What is that?
That is a letter issued by the Ministry of Environment, Forest and Climate Change to the state government. As regard to diversion of forest land, its subject is diversion of 434.935 hectare of forest land, the forest area in the bauxite mining lease, such and such land in September, June, and such hectare forest land out of the such area for construction of a approach road to the mining for a mining of bauxite, and for this the circular has been issued by the government of India.
All of you see, he is the state government, you are the central government, he has a grievance relating to illegal mining. Both of you can see and take a decision.
Naturally,
It should,
yes, definitely.
third learned counsel for the petitioner. Learned Deputy Solicitor General for the Union of India and learned AGA for the state of Orissa. It transpires from the pleadings on record in the present writ application filed in the nature of public interest litigation that the petitioner has raised issues regarding irregular mining operations in Kodinga Mali Community Reserve Forest. Why Odisha Mining Corporation?
Yes, that is what I wanted to submit before. If your lordship will permit me, I will. Your lordship may kindly have it only 1 minute. Have a glance on page 21, the prayer, page 21. Prayer number C is important. That is the only substantive
Page
prayer.
21.
Page 21 of the writ petition.
Yes.
Paragraph C is the important prayer. That is the substantive prayer.
Yes.
And after hearing all the parties concerned, the Honorable Court be pleased to issue a direction or order to stop the mining operation and quash the forest clearance and execution of fresh Grama Sabha in the surrounding villages of both. So the basic prayer in the writ petition is to quash the forest clearance which is given to the for mining operation. And that forest clearance has been given by the Government of India. And in favor of whom? In favor of the project proponent, which is a company, Alumina company. And the OMC is the leaseholder. OMC has, by virtue of a MOU, that is also annexed to the writ petition, has engaged that bauxite company first. So my response submission is these two entities, OMC and the company, their project proponent, their necessary parties, if any order is passed or any representation is considered, they have to be heard. That is my response submission only.
We are not issuing any direction.
You can consider that representation giving opportunity to those.
That may be kindly be noted in the order. That is my response submission.
Hindalco.
Hindal. Hindalco Industries Limited, HIL.
by Orissa Mining Corporation bracketed OMC in Lakshmipur block of Koraput district in Odisha. Full stop. In the petitioner is seeking a direction to stop mining operations and quash forest clearance and execution of press Gram Sabha. Gram
Gram
Sabha. What is Gram Sabha?
That is a meeting to be held in the area amongst the local villages.
Mining operations are given.
That is a preliminary requirement for granting.
They are not publicly doing this.
In the
Given to the
The villagers-
public hearing
In public hearing, they will render their views public
in presence of collector
in
and
presence of district administration.
Not comes under the public hearing, sir. This is the Gram Sabha comes under the PESA Act. And public hearing, that's a separate chapter, my lord.
Mr. You should have approached the National Green Tribunal. Why
That is-
such thing before this court?
These are the matters to be dealt with by NGT.
Why unnecessary? Next, considering the issues which have been raised in the present writ application, that in the nature of public interest litigation, we dispose it off with an observation that the grievance raised in the writ application may be considered by the Ministry of Forest and Environment and the department, which department? Department of
The
Mining
collector is the opposite party number 2.
and the collector. Which district?
Raigada.
Yes.
Raigada, I think. No, or Koraput. I'm sorry, Koraput. Koraput post.
Oh, next. This
Opposite part
application stands disposed of accordingly.
Item number 7.
Mr. Turk.
Sure. Are you appearing? Are you in person?
Yes.
Yes, my lord.
Are you appearing in person?
Yes, my lord. In person.
But you should not have any in your robes.
Yes, my lord.
While appearing in the High Court in person, you should not wear the gown and
Where will gown, sir? My lord.
You should not use goods in
You should not use.
My lord is saying.
band and the gown you should not use. You should when you are
He is unable to understand.
no. Mr. Turuk, Mr. ଯେତେବେଳେ ଆପଣ appear କରୁଛନ୍ତି in person ରେ ଆପଣ ଯେହେତୁ advocate ଅଛନ୍ତି in person ଯେତେବେଳେ appear କରୁଛନ୍ତି court ରେ ଆପଣ band ଟା ଖୋଲିଦେବେ gown ଟା ପିନ୍ଧିବେ ନାହିଁ ହେଲା ହଁ ଆଉ ଯେତେବେଳେ client ପାଇଁ appear କରିବେ ସେଟା ଚଳିବ
Yes, next.
Item number 7.
Item number 7, I filed the interim application for extension of time loss. Saying for 1 month time to
May I draw your lordship's attention to the last order, that is 8th of February 2020. There is a positive statement being made to comply the order by this date.
What was the order?
The order is for grant of fire safety certificate within 3 weeks. It's an institution, educational institution is running without a fire safety certificate, my lord. that page 31 is the direct ordering portion. The respondents are directed to comply with the order by order dated 31st August 2023 by granting the renewal of fire safety certificate within a period of 3 weeks from today. Well, renewal has been refused, for which I approached for a lordship. Say education, lordship can consider say educational institution running without a fire safety certificate, and the consequential problems are also be there.
Is it that case where we have held that in rural area it is not required?
Yes.
Old buildings,
Yes, madam.
that is not
That's
required.
not, and it has
That's
the building plan. And now the extension is sought for on the ground that they decided to go to file SLP. And already 90 days has passed. And in any case, without the certificate, the risk of fire and everything is there, and there is a criminal liability will be passed in. They granted us the fire safety. While renewing, they didn't renewed it on the ground that
So what was there in the order dated 31?
31 is also in the REIT application. There is a direction to comply to grant fire safety within 3 weeks. Subsequently, that order was reviewed, and
So what was there in the
that
order?
that
31/8/2000.
I'm passing on, my lordship. That 31(3) orders. Paragraph 7, my lord. In the result, writ petition stands disposed of in terms of the above as necessary. Collectively impugned order under Annexure 1 is hereby quashed with direction to the opposite party number 2 to consider it, the renewal application that is under Annexure 5 in the light of the direction issued herein above, and to take a decision therein at the earliest, preferably within a period of 3 weeks from the date of receipt of this order.
And where is the review order?
Review order I have annexed, my lord, at Annexure 2.
40.
Page
Page 40
32.
is the last part.
Yes, my lord, page 40.
13 and 40.
Yes.
And when was this order passed?
This order, writ appeal was passed in,
No, writ appeal.
writ appeal was passed on 14th December 2023.
23.
Yes, my lord.
How much time was granted?
3 weeks, my lord.
No, I filed the IA application for time.
Where?
There interim application also, that is also IA number 187 of 2024.
When did you file?
Yesterday I filed.
It's not there.
It's today the copy has been granted. Today the copy, lordship kindly have
Directed
this.
by learned AGA. That we will take up later. AGA that an application has been filed. Interrogatory application has been filed seeking extension of time for compliance of this court's order.
No, compliance, we Supreme Court challenging the order because it has got long ramification.
Okay.
Mrs. Compliance of those
All right.
approaching the higher authority.
Have you filed?
No. Yes, administrative, because the DG of Fire Services has already requested the administrative department, that is Home Department. And
We are not saying anything then. We are just adjourning it
Adjourning,
for a
no,
week.
I'm okay.
I requested on behalf of learned AGA, by learned AGA for the state of Odisha, list this matter on 1 week. If you can file within 1 week, you can inform.
Well, I will.
To next week, man.
2 weeks.
But
2 weeks.
2 weeks. Your lordship considered this, there's a students being there in the building, it's without any fire safety certificate.
No, the question is
Yes, ma'am.
that the order was passed in December 2020.
Yes, ma'am.
Any party to a proceeding has a right either to accept the order or to implement it, or to defy, or to prefer
My lord,
appeal
absolutely,
against that.
absolutely.
So if they intend not to comply with the order because they want to prefer an appeal, then that will not constitute contempt.
But that period is 92 days now. The limit is.
So we will
period
not
is-
be too technical.
I agree, my lord. In that case, they at least they should cover without the prejudice to their right. They should grant the provisional certificate because the educational lordship kindly also understand here, the educational
We will
institution
see,
building is also
we will
running
see.
without fire safety certificate.
we will see after.
Because
2 weeks.
tomorrow,
Right.
any untoward incident, then the persons will be roped in for criminal liability. I don't deny, man, they can even contemplate to grant me provisionally without prejudice to their right in the SLP. The reason for which they are granting, they are not led without prejudice to that reason. They grant if it is found to be otherwise fit. I fully agree with what your lordship is proposing. They have a right to appeal. I don't deny that. But lordship says hundreds and students are there. There are at least 10 numbers of building of this present institution is involved here. So the students' strength running to 5, more than hundreds are doing. There may be any untoward incident which we cannot be contemplated today.
No, but what is your problem? They are not giving you certificate on.
Yes, my lord.
Otherwise, you have all these.
All this, my lord. The only thing they are not granting me that they are saying that you do not possess a building regulation approved building plan. I have the approved building plan and I have shown it before your lordship in all these forums before the honorable single judge and division bench. Now what I say, they say this is not in compliance with the rule. So without prejudice to that, that's the only requirement they are showing. Without prejudice to that, let them give me 5 provisional.
Your plea was it was in the rural area?
Yes, my lord.
And the
Rural
building was
area,
old building.
old building. It
And
has
it was prior to that law.
prior to even coming up this fire safety regulation
From
2017.
municipality or NSE, you have got that
Yes,
approved
madam.
building plan.
So
That is
the
that reference point of-
only requirement which they are saying that I'm not having is
No, why should they give you certificate?
no, my lord, otherwise the under 2017
So
rule.
because of the grant of certificate, the safety measures shall be there.
Yes, my lord. All
Because certificate will ensure that no mishap happens in
no,
the.
no, my lord. I am not on mishap, my lord. If mishap hackers, then I will be in criminally. So my affiliation and other things are also being blocked for this.
Already you got the affiliation and other NOC and. Now
Only that,
renewal-
but that everybody, but thing is a provisional because
For re-
want of fire.
For renewal, you are facing.
Yes, yes,
problem.
ma'am. That's the problem.
Are they duty bound to issue certificate, safety certificate?
No, my lord, once I'm eligible, they are bound to give me. Otherwise, I cannot use that premises for any purpose because the classes of building was defined under 2017 rule is one such building which requires fire safety certificate. And once the measures are there, they are bound to give it. Since they have denied, I have come before your lordship.
Yes, we have shown that some deficiency at that and we had called upon them to comply that so that it can be given. That order was challenged because we said that.
No,
order-
but since today you have not complied with the order and you are planning to file SLP,
No.
you are initiating contempt proceeding against you. In the meanwhile, you may file your SLP. With the Supreme Court stays, we will stay.
As your lordship said granted 2 weeks time, in the meantime, I'll see that provisional members will also consider, also may call it 2 weeks after lordship.
It is an admitted position that this court's order dated
And last of all,
14/12/2023 passed in WA number 2967 of 2023 has not been complied with. First of operative part of the state order reads thus. Good. Good. Stop. From the submissions advanced on behalf of the parties, it appears that no step has been taken for implementing the order. First of learned AGA has submitted that the state government is contemplating filing an SLP against the state order. First of, next, be that as it may, till date, neither this court's order has been challenged nor complied with. First of, in that circumstance, the court's opinion case is made out for initiation of contempt proceedings against the contemners. First of, let the contemners file their so cause as to why contempt proceeding be not initiated against them and they be not punished for deliberate disobedience of this court's order dated 14/12/2023 passed in WA number 2967 of 2023. The so cause must be filed within 2 weeks from today. List this case on 2 weeks.
May I pray for 1 week more?
No, 1 week less. I thought you were saying, may I pray for 1 week instead of 2 weeks?
So we can also issue notice of contempt action chambers also.
My lord, this is second contempt matter, my lord. My father was suffering from schizophrenia, my lord. Hence, I am looking after this case, my lord. Respondent all time, my lord. Time court order non-comply the any other order, my lord. And again, bad illegal work, the respondent so cause not filed on 8/11/2023, my lord. and all
Where
time.
is the order?
Your Lordship, in this case,
I will take the instruction, but what I am suggesting, my lord, instead of his personal appearance, this all it was drafted I gone through. So may I suggest, my lord, this any counsel from the legal aid
That we
maybe?
will do, but where is the order?
There is no order. That's why I'm
Page 30.
only
Page 30.
cat order. Cat there is 2-3 order is there passed by the Lord Central Tribunal. That is page 30 and
Page 30.
page 30. Order reserved is there.
no reason.
There is no such order. Then page 28.
Dispose.
Order is not pronounced.
My lord, 30 page रे मोदे कि contempt is dispose of my lord. Ex party करी के dispose करा जाई छै. से माने शो कॉज देले नहीं मार. So cause not filed, my lord. And again harassment, my lord, my family and my father, my lord. So again order to High Court, my lord.
ଆପଣ ପେଜ 30 ରେ ଯୋଉ ଦେଇଛନ୍ତି
My lord.
ସେଟା ହଉଛି 8 ନଭେମ୍ବର
8/11
23 ର ଅର୍ଡରଟା ଦେଇଛନ୍ତି ରାଇଟ୍ ସେଟା କମ୍ପ୍ଲାଇ ହେଇନି କହୁଛନ୍ତି ସେଟା ଆହୁରି ଏପର୍ଯ୍ୟନ୍ତ
ଶୋ କଜ ଦେଇନାହାନ୍ତି ମାନେ
ସେଟା ଶୋ କଜ ନୁହଁ ସେଟା ଅର୍ଡର୍ସ ରିଜର୍ଭ ଅଛି ହିୟରିଂ ବୋଥ ସାଇଡ ହେଇଯାଇଛି ଆପଣ ଶୁଣିଛନ୍ତି ସେ
ହଁ ମୁଁ ଥିଲି my lord ସେଟା hearing ହେଲା ସେ ଏକ୍ସପର୍ଟି ସେମାନେ
ଟ୍ରାଇବୁନାଲ ଆପଣଙ୍କୁ ଶୁଣିଛନ୍ତି ଅପର ପକ୍ଷକୁ ମଧ୍ୟ ଶୁଣିଛନ୍ତି କରିକି
my lord ତା ପୂର୍ବରୁ
ହଁ ବର୍ତ୍ତମାନ କଣ ଆପଣ ଚାହୁଁଛନ୍ତି
my lord ଶୋ କଜ କରୁନାହାନ୍ତି ସେମାନେ କି କିଛି କମ୍ପ୍ଲାଇ କରୁନାହାନ୍ତି ଅର୍ଡର କୁ
କଣ୍ଟେମ୍ପ ଟା କଣ ହବ ଏଠି
हिंदी समझते हैं?
हाँ
क्या चाहिए आपको?
my lord मैं शो कज नहीं दे रहे हैं इसलिए मैं
शोकत में उससे आपको क्या फायदा हो?
सर शो कज देंगे तो मेरा ऑर्डर को पोस्टपोन मतलब
क्या चाहिए? क्या ऑर्डर था? क्या चाहिए? आप भूल जाइए सारा कुछ, ऑर्डर कंटेम्प्ट सारा भूल जाइए। वो क्या चाहते हैं आप?
सर मेरा पापा का ऑर्डर हुआ था सर फिट पर ड्यूटी के लिए सर उन लोग फिट पर ड्यूटी भी नहीं दे रहे हैं या अदरवाइज अनफिट भी नहीं कर रहे हैं सर इसलिए सर कुछ भी ऑर्डर मान रहे नहीं है और कुछ भी नॉन कंप्लाई कुछ भी कर रहे नहीं है सर
कोई इलाज की जरूरत नहीं ना है?
हाँ
किसी इलाज की तो जरूरत नहीं है ना, ये नौकरी का मामला है।
जी मैडम
कोई मेडिकल सपोर्ट की जरूरत नहीं है आपको ना।
मेडिकल फिट फॉर जो मेडिकल फिट फॉर ड्यूटी के लिए किए थे ऑर्डर उसको तो नॉन कंप्लाई किए मैंने
वो डिसमिस कर रहे हैं आपका आवेदन। आप किसी
माइलर डिसमिस
वकील साहब से बात करिए, फिर करिए। और अगर आपके पास कोई वकील नहीं मिलता है तो आपको एक वकील हम लोग मदद करवा सकते हैं आपकी। Petitioner has appeared in person. He has filed this contempt case for taking action against
माइलर डिसमिस मत कीजिए मेरा केस को मैं इतना दूर से आ रहा हूँ अभी इतना
against the contemners. Have they given names? यहाँ जो फाइल किया उसमें भी आप खुद अपीयर करिए। तो आप तो मुश्किल कर रहे हैं ना, आपको कोर्ट को मदद करने काम करने दे रहे हैं और ना आपको कोई फायदा मिल रहा है। आप समझते हैं कि कोर्ट का भी आप कर ले सकता है। आपको अगर किसी जरूरत है किसी लॉयर की तो वो करवा देंगे, आप तो मुश्किल कर रहे हैं, कोर्ट का समय भी जाया कर रहे हैं और जबरदस्ती आप आर्ग्यू भी करते हैं।
माइलर मैं वकील को ही दिया था केस माइलर वहाँ मेरा केस को आधे रास्ते में छोड़ दिए थे सर।
तो आधे रास्ते में छोड़ दिए थे तो हम यहाँ पे हैं ना आपके लिए, देखेंगे क्या हो सकता है। समझ रहे हैं आप?
जी माइलर मैं ये चाहता हूँ माइलर आज मेरा प्रेयर है।
आप चाहते हैं और हमारा जो लिमिटेशन है ये दोनों में फर्क हो सकता है, समझे? आप जो चाहते हैं हो सकता है हम नहीं दें, आप जो चाहते हैं वो आपको समझ में नहीं आ रहा है कि आप उसको कैसे चाहिए, कैसे कर सकते हैं आप। तो ये वकालत की पढ़ाई वैसे तो नहीं है ना,
जी मैडम,
लेकिन
लेकिन
वो करके प्रैक्टिस करके साहब खड़े हैं वहां पे, और आप सीधा चले आए हैं और कहते हैं कि आप ही करेंगे क्योंकि वहां अधूरा छोड़ दिया, तो आपको रोक तो नहीं सकते हैं यहाँ आने से।
आप बोल रहे हैं कि शोकस रिप्लाई नहीं दे रहे हैं, ये भी गलत बात है, बिकॉज पेज 29 में
जी मैडम,
जो ऑर्डर आप दिए हैं
जी।
4 अक्टूबर का,
क्या
राइट,
प्लस
वहाँ लिखा है लर्नड काउंसिल फॉर रेस्पोंडेंट सबमिटेड दैट ही हैज फाइल्ड शो कॉज रिप्लाई, देयर आफ्टर हियरिंग वाज कंडक्टेड, हियरिंग हुआ, बोथ साइड का हियरिंग हुआ, फिर ऑर्डर्स रिजर्व हुआ, इसके बाद क्या हुआ?
उसके बाद कुछ नहीं हुआ।
कुछ नहीं हुआ।
कुछ नहीं
So
हुआ तो
cause
आप
was
समझ-
filed.
No,
Office of-
order passing.
Sitamu, I don't have the instruction, my lord. But only my lord may see page 13, there is a
Just
order,
a minute, what we are going to do,
my lord.
we are asking him to, you are in the front row. You take up his matter,
Yes, sir. So, yes,
you advise him properly,
sir.
and then you please tell us
Yes, sir.
what can be done for him.
Yes, your lordship.
If there is something, then we shall do, otherwise,
Yes, your lordship.
It is better, yes.
the petitioner has appeared in person. So we are of the view that he is not at all capable of presenting his case and requires legal assistance. So at the court's request,
Prabodh Chandra Naik.
Yes, sir.
Nair has agreed to take up the petitioner's case and advise him for appropriate course of action. So list this matter on 1 week. आप उनसे मिलिए,
माय लॉर्ड, मैं मेरा प्रेयर तो एक्सेप्ट करके एडमिट करके सुनो तो मैं इतना दूर से सिर्फ 2-4 साल से कोर्ट का चक्कर में सर 7 सालों को जो
आप बाद में उनसे बात कीजिए, उनका फोन नंबर लीजिए और उनको मुलाकात कीजिए, वो बताएंगे क्या।
वो आपसे फीस नहीं लेंगे, समझ रहे हैं ना, वो फीस भी नहीं लेंगे, बहुत महंगे वकील हैं, फिर भी वो फीस नहीं लेंगे। आप वो जैसा करेंगे हम लोग देखेंगे, अदरवाइज ना आप हमको समझा सकते हैं ना हम आपको समझा सकते हैं, समझ रहे हैं ना। हाँ
सर, लेकिन
क्योंकि ये जो वकील साहब लोग हैं, ये एक तो लॉ की पढ़ाई की इन लोगों ने, उसके बाद 20-25-30 साल से यहाँ प्रैक्टिस कर रहे हैं, तब आर्ग्यू करते हैं। आप कमरे से सीधे चले आए यहाँ पे और कहते हैं कि एक्सेप्ट कर लीजिए।
सर मैं दिया था सर वहाँ
हो गया बहुत, चलिए बहुत हुआ।
My lord is fixing any date.
1 week. Just for him to hear him, he will.
Yes, yes. Let them is, Mr. Naik will assist him all this way.
So what is-
I will see that how it best can be done.
And we will also see what help can be.
Yes, 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 definitely, ma'am.
Item number 9.
Item number 9, the original order was not included, but now my friend has given me a copy. I only pay a loss, may call it next week so that I can obtain, because there was a direction for consideration representation only. I'll obtain instruction next week only.
On behalf of the state, let's do matter on 1 week
কমপ্লাই হয়ে যাইছি রেডি।
to report compliance.
Item number 10.
In Insomilus, the order dated 23rd February 2023, related the writ petition filed by the legal heir of the deceased father, who is a contractor. His due some security was not released. Your lordship direct to consider this application, the legal representative before your lordships.
Where is the order?
Page 12, your lordships.
Page 13, paragraph 5 is the direction, my lords. Lordship, also give me time because there was a direction to consider the annexure 15, that is the representation, my lords.
So, have you disposed of?
I will obtain instruction because it has been listed for the first time. I'm not, only next week only, I don't pay for most time now. Next week I will see that.
This is matter on 1 week, so as to enable an AGA. Keep instructions as to whether the court's order dated 23/2/2023 passed in WPC number 5062 of 2023 has been complied with or not.
Item 11.
11, your lordships, the non-compliance of the order dated 15 September 2023 is start from page 10, your lordships. This is the VKD infrastructure by taking a retrospective operation of circular, and the circular in the judgment of this honorable court now, my lord, confirmed by the Supreme Court, my lord. And this has not been complied with.
It's the same, lords. Next week I'll also may call it, I will obtain instruction whether it has been complied with or not.
Same order.
Obliged.
Item 12.
Item 12, my lord, this contempt question is filed for the second time, my lord. Matter relates to eviction of my lord encroachers from the my lord Gochar and land, my lord. My lord, that order dated 19/7/2023 was not complied. Even though we have heard personally my collector Sundargarh, till that neither it was complied nor the encroachers were, my lord, evicted from their Gochar land.
Just now I have obtained instruction, the case has been considered and it has been disposed of pursuant to the lordship direction since lords 25th of August 2023. I can find that
After first
affidavit.
contempt order.
No.
After first contempt order.
Yes. After the direction was given, it has been complied with. I can file that affidavit before.
It hasn't complied with.
Yes.
Then give him.
Yes, I've got a copy.
This is for the second time, my lord.
All right, it has been complied with now.
Yes, my lord.
It is stated by learned AGA that this court's order dated 6/2/2023 has been complied with in as much as has been complied with. This is order dated 6/2/2023 passed in WPC number 2033.
Yeah.
2033 of 2023 and order dated 9/7/2023 passed in contempt case number 3553 of 2023 has been complied with. So a copy of the order, that is an order.
Yes, I've given it 25th of August 2023.
A copy of the order in compliance of this court's orders. Order passed by whom?
The collector,
The order
Collector Sundargarh.
passed by the collector Sundargarh in compliance of the court's orders as noted above has been produced before us, a copy of which has been handed over to the learned counsel for the petitioner also. Contempt proceeding stands dropped accordingly in view of the subsequent conduct of the contenders. Since some contenders of the violation of this court, disobedience of this court's order does not appear to be intentional and willful. So the contempt proceeding stands dropped accordingly.
Item number 13.
Yes, item 13, both cases will also grant me each time I have to obtain instruction. I think.
I'm appearing on behalf of Anirudh Sanyal.
13, 14, 2 weeks. 13 to 13. Both. 13, there are two cases.
Two cases, Lord.
Two
Both
cases.
This case is also in Supreme Court you lost.
Yes, the same.
Raghunath Sahu.
benefit.
Ah.
Connected, relying on that BKT construction.
BKT.
Grant the benefits only.
For orders, item number 14.
Achha.
Yesterday matters saw that.
Yes, yes. We have noticed typographical error in the order dated 4/3/2023, wherein comma the fourth line of first paragraph of the order in WA number 1280 of 2022. 2003 has been typed in place of 2023. 13. First off, the said order shall be read accordingly.
Correction. Asterisk correction. And then
the registry is directed to offload the said order dated so and so and upload this corrected order. Okay.
Item 14. Sir, item 15.
Item 15 and 16. My lord, no, Sarath Parade.
Sarath Parade.
Man.
15.
My lord, sir, should I say the background, my lord? These judgments, which was a first day disposal, batch of cases were heard by my lords. Then pursuant to remand, the Honorable Single Judge heard the same issue afresh and has passed another order. So these matters are to go back. Or my lord may hear because, but the order has
What happened?
my lord, both 15 and 16, both.
15 and 16.
Item 17.
My item 17, my
My lord,
kindly pass over.
delay it only.
Delay.
Because in all those cases, my lords have condoned delay and because all cases are same.
17.
My item 17, kindly pass over, my lord. Mr. Pali. Mr. Pali, submit me. Pass over.
What do you want?
My senior, Mr. Suvit Pali, will address my lord. Pass over, my lord.
As requested.
Item number 18.
18, my lord, today my lord is taking up that matter, item 27, where this issue, Lord Advocate General will address my lords, along with item 27. That work charge employees regularization. My lords will be hearing it today.
My lord, I am appearing in item 27. I am in virtual mode, my lord. My apology for lordship, my lord.
This is item 18.
18 is like 27. If the Advocate General is ready, my lord, we are ready, my lord. We have been suffering for last 30, 40, 35, 40 years. Not getting regularization, not getting, despite the undertaking given by the state to the Supreme Court.
All right, we'll see. Have you seen full bench decision of Patna High Court on this point?
No, my lord, here is a case where they had undertaken before the Supreme Court in the year 1995
All
to
right,
regularize our services.
all right, we will see.
Mr. Misra, there is some amendment thereafter.
Yes.
We will.
My lord, in fact, my lord, item 18, my lord,
Yes.
item 18, my lord, I have instructions to appear and I'm on caveat for the respondents. This case, my lord, cannot be equated with the batch of in item 27, my lord, for 4 primary reasons, my lord. If your
No,
lordship
we are not.
Yeah,
We are not tagging this matter.
I'm obliged.
We will
I'm
decide the
kindly
matter
hear this
after
separately.
27 is decided.
Yes.
Very well. Very well. Deeply obliged.
Item 19.
Item 19 were led by Dr. Singhvi, who's appearing to this.
May it please you, my lords. May it please you, my lords.
Yes.
Whereas actually this matter is with greatest respect and humility, whereas not so much with any other party respondent. Of course, they are there. It's only a request from our side. Your lordship may extend the time. Now, it's time being taken to consider the matter or file replies and all, subject to my lord's kind discretion, may not be necessary. I have given your lordships in the application 3 basic points. The earlier person did all this. Your lordships had in principle approval. Efforts were made to do it in this time. They're all described. But unfortunately, these things are partly beyond our control because these high-powered bodies sit very occasionally and sparsely. So we are saying, we are very, very confident that we'll be able to really,
Mr. Singhvi, the situation in this case is that illegality is admitted.
That is from the past person. That is why the regularization. Absolutely right.
So you have purchased illegality. You have acquired illegality.
Whereas I have not purchased. I have under an IBC procedure, as your lordship knows, in the IBC.
No, sorry, we use the incorrect expression.
No, not that's not the word. But your lordships has created provisions in the IBC, in fact, which is argued in the main matter of extinction of illegality also. In fact, now your lordship, as I pointed out in the main matter, 32A has been enacted that even criminal proceedings, where the corporate debtor will cease. 32 has idea of IBC is to give a clean slate. Your lordship knows those famous words of Justice Nariman, that it is to prevent ambush or clean slate because knights in shining armor will not come to help out companies if they are being punished for the past misdeeds. Here the problem was that there was some 35 hectares which is regularizable and is been in principle regularized. But the final regularization is taking time. That's the only problem.
Yes, we saw the Ministry of Environment. Someone is appearing.
My lord.
Yes, why are you not taking any decision? Why no decision is being taken?
We have received the instruction.
We have received the instruction.
What?
This instruction is upon examination, it was observed that it is a case of willful violation and there are shortcoming in the proposal information submitted by the state user agency. According to the ministry is by letter number such and such, copy enclosed. This letter is enclosed.
No, when was this order passed?
That order was passed on 26/2/2024.
Whether this has been supplied to him?
It's part of our application.
Right. It's part of my application. This is only a letter. Only a letter.
Final approval is awaited, my lord.
So why are you not taking any final decision?
Your lordship has by the order dated 14/8/2023. Your lordship has directed not to take any final decision. There is the order is there, my lord.
Where is that?
I can have a grant. It is.
But after that, 4th September was passed.
Para 19 of 4/9/2023, my lord. Para
Which
19,
page?
my lord.
Which order?
Order 9/2023.
Order number?
4/9/2023. Passed by the Supreme Court. I am placing that. Yes.
Just a minute.
Paragraph.
19, my lord. 19.
19.
We extend the time for execution.
Please.
So where were you prevented from taking a final decision?
And order determinant 14.
Para 20 is very clear.
Yes. 14/8/2023. Can have that order. It is under this session, my lord. No final order has been passed. They have seek some instruction from the state government.
Mr. Counsel,
regarding-
you have drawn our attention to a particular order
Yes, sir.
and you have asked us to read para 19. You see para 20 thereof.
Yes, sir.
What is your reply?
And in that order, my lord.
You are representing whom?
Is my, or one of our CGC is allotted the case, that's why.
Central Government Council.
And in that order, my lord, if in the meanwhile, the final order accepting the forest diversion proposal and leasing out of the land by way of regulation is passed in favor of the applicant, our order dated 14/8/2023 shall be automatically restituted for execution in similar terms as reflected in the order dated 14/8/2023, my lord. Pursuant to this order, my lord, before that, my lord, on 26th, in the instruction I have enclosed.
Why are you not reading enter?
Yes, ma'am. Thereafter, my lord, the state opposite parties shall, in that event of failure of the applicant to produce the order of regularization and leasing out, shall take immediate action to vacate the enclosed forest land. The prayer for directing the MOEF, the MOEF to pass the final order is rejected, madam.
Then 20.
Yes, ma'am. Till expiry of the extended time, the status quo as on today shall be maintained in respect of the forest land.
Thereafter, there is no status quo. That period is over.
Yes,
Status quo is not there.
yes.
That is what my lord is asking you. Where is the restrainment?
No, what happened, madam?
No, Mr. Counsel, we are under the impression that you are not taking any final decision because of some order passed by this court. Is it so?
Yes, sir.
Where is that order?
Madam, we have not till yet passed in final order.
Why?
What happened actually, madam, the ministry has called for all the documents, but the state government is not providing the documents. So, far as I am enclosing that instruction, I have received. To lordship, I have handed over that instruction. They are not providing the documents, madam. It is
You file an affidavit, we will see.
yes,
May
madam.
I make it simpler for 1 minute if your lordship will permit? Subject
Yes,
to my
ma'am.
lordship.
Yes,
I'll just take
Mr.
2
Singh.
minutes without opening the papers. Manas, there are 4 dates. The last date is the 4th September order of your lordships. Now, no doubt your lordships gave me 6 months, which is why I applied within that time for extension. Now, my learned friend here has written on 26th February 24, that is the last one after the order, asking the state to inspect. So he is moving. The problem is, Manas, like an elephant, he is moving very slowly. Now, Manas, this movement, they ask on 26/2, after 4 or 5 months, for the state to inspect. Now, the state will go and inspect. We are asking them urgently. The state is also here. They can do it. Then, Manas, thereafter, if they are asked to decide within 2 months of that, this will solve the problem. My learned friend writes a letter after 5 months saying, please come and inspect. That's
No,
the
but
letter.
Mr. Singhvi, there was a similar prayer made earlier for direction to the Ministry of Environment and Forest to take a decision. That was rejected. So we will just ensure that this is expedited. The decision making is expedited.
Yes.
This we will try to ensure.
Yeah, that is the only thing. Ultimately, they have to decide.
May I pray one thing, man? Let me keep you up to 10 days. In the meanwhile, the latest information I have got to. My lord is given my senior given a comment that the government is going on very elephant manner. It is not a fact. We will very much conscious about the issue. Within 10-15 days, we will take the proper instruction. Let's make pass necessary.
as requested on behalf of IA number
IA number as well as
3265.
3265.
Learned Solicitor General for India, learned Deputy Solicitor General for India seeks adjournment to file a reply to this application after seeking instructions to stop. List this matter on 2 weeks. To stop. In the meanwhile, the parties shall maintain status. Will that do, Mr. Singhvi?
Yes, well, I'm grateful. Of course, after the 10th day or 15th day, they will have to give a schedule to by which they will decide it one way or the other. But as an interim situation,
We will see.
Of course, your Lordship has said status quo. Obviously, it is obvious it doesn't prevent them from considering these inspections and all this and doing the job. Otherwise, they'll come up with some other reason like that.
We will see. We will, in fact, if they are not moving, we will make them move.
Yes.
Take a decision this way or that way.
No, I'm saying, well, your Lordship, status quo word should not be understood by them to mean status quo regarding decision making.
Last time my lordship for forest land. For forest land. My last
In respect of the land in question. All right.
Obliged, Malus. Can it be the first week of April, Malus?
It will be taken up, Mr. Singhvi. When do you want?
But is it possible on 4th of April, subject to my
4th of April, all right. 4th of April.
Little more time can be.
No, 4th is more than 10 days.
4th, let's make keep it to.
Then let it be 8th, Malus. 8th.
It's fine. 8th.
8th.
Obliged. Deeply obliged. Deeply obliged.
Item number 20.
Item 20, may I please, Your Lordship?
Yes.
Your Lordship, on the last occasion, Your Lordship had extensively heard the matter. I have only one last submission to make.
Again.
To the good conscience of this Honorable Court, Your Lordship. Your Lordship, in fact, there has been a great delay in pursuing the case, Your Lordship. However, it cannot be made attributable to the petitioner. And had the same case been taken up, Your Lordship, 10 years before, Your Lordship, I would have prayed Your Lordship to give him another chance in the light of the judgment, Your Lordship, to pursue the required qualification.
Let's come on Monday. We are not ready.
Your Lordship may consider only this submission.
You may be ready, we are not ready.
Obliged, Your Lordship. Only this submission, if Your Lordship may consider, that still 4 years of service is left of the petitioner. If Your Lordship may be so benevolent to pass an order.
I admire your perseverance.
Obliged, Your Lordship. Monday.
Yes.
Obliged, Your Lordship.
Item 21.
Item 21, my lord. I pray this matter may be taken up next week. Item 21. I pray
21, what do you want?
I want a matter may be taken up next week because of my some personal difficulties.
All right. I have requested on behalf of the applicant on the ground of personal difficulty to discuss matter on 1 week.
Item 22. Sorry. Item 22.
Item 22 state here the appellant. May I pray your lordship may take up this matter tomorrow or
what happened?
May I pray this matter may be taken up tomorrow?
Why?
Because my
Tomorrow I will discuss.
Request. Item number 24.
Your Lordship, item 24. Your Lordship, I pray for a Passover.
Item 24.
Your Lordship, item 24 for the appellant. Your Lordship, I pray for a Passover as my learned senior is oddly placed.
1 week?
Obliged.
Requested on behalf of the petitioner
The difficulty faced by the licensee photographers. Therefore, I pray any date earlier.
Tomorrow?
My lord, can it be Monday? Tomorrow I will not.
As my senior is requesting Monday.
Item 25.
Pardon to mention, my lord. I am the one of the respondents in this read appeal. The WA number 1767 of 2022.
You are appearing for the appellant.
Respondent, my lord. But the copy has not been solved. I pray that copy may be, the read appeal may be solved.
I'll serve in course of the day. Your Lordship can take up this matter tomorrow, my lord. I'm ready in this case, Your Lordship. Because other respondents are ready for disposal of this read appeal. So Your Lordship can take up all this. Very short question is involved. I'll serve in course of the day.
In course of the day means I have to read it.
So then Your Lordship may call this matter on Monday.
Let Mr. So accepts notice on behalf of which all respondents.
No, he is appearing in one case.
One of the respondent, I am appearing in WA number 1767. Other respondents are my lord. How is
Pardon to mention, my lord. In item 25 out of 26 matters, I am appearing in 18 matters on behalf of the respondent. In the first leading case, I got the copy and I have filed my counter affidavit. And the other cases, my lord, since the delay was there and they have not supplied me the copy also, Your Lordship may direct to...
So we will just take up the matter on the next week.
My lord.
In the meanwhile, they will be supplying you the memo of appeal.
My lord.
All right.
My lord.
And we don't know whether there will be requirement of issuance of notices to
Yes. The leading case is a copy pleading completed. The first one, I have already...
list this matter on 1 week as requested on behalf of some of the respondents in the present set of appeals.
May I pay, my lord, other two left out matters, 148 of 2023 and 552 of 2023, read appeal, may be tagged to the same similar issue.
Which item?
This is not in the board, my lord. The read appeal 148
yes.
of...
Is it correct?
Yes, ma'am. 148 of 2023 and 552 of 2023, read appeal.
Same order.
Similar issue.
Similar, no. Whether the order is same or not.
My lord, order is same.
What? There is one order under challenge.
Yes. One order is under challenge. And relying that order or the read petition have been disposed of.
List this. Along with WA number so and so. State council shall be required and AGA shall be required to serve copies of the memo of appeal upon learned counsel who have entered appearance for the respondents. Yes.
Next week, my lord.
Next week.
Item 26.
Madam, for the appellant, and the order included is order dated 22 April 2022. Before I take your lordship to the impugned order, may I just say the appellant is a MSME.
And which is that order? Where is that? The order?
My order is 26, page 26.
So you are challenging this order?
Yes, ma'am. So, may I just take a very small actual background, madam. The appellant is a small scale industry enterprises. It approves the Micro, Small and Medium Facilitations Council, alleging that the buyer has not made payment of the supply which he has made. there was an work order in the year 2010. The supply on the basis of the said work order continue up to 2018. And the 18 when the service was completed, they have granted me the completion certificate. In between, in 2015, I took the memorandum of as a micro small enterprises has been filed before the authorities. Now the question they have raised in this writ application is that admittedly my registration as a small scale industry is with effect from 2015. But the work order was 2010 and the supply period continued up to 2018. So they raised that at the time of entering into agreement, I have no registration or memorandum as small scale industry has not been filed. But it's also a fact that from the date of the filing of the memorandum, that is in the year 2015 to 2018, I also continue to supply the service. So there are two periods. One is from 10 to 15, when I admittedly have no memorandum, and the other period is from 15 to 18 when I have. Now, when they didn't make payment, the buyer didn't make payment.
Who is the buyer?
Buyer is the respondent. Respondent number one.
Who is the respondent?
It's a government of India, PSU. When they didn't make payment, I invoked the jurisdiction of the council, that is Micro, Small and Medium Facilitation Council, functioning under the Micro, Small and Medium Enterprises Development Act 2005. I approached the MSEFC Council. MSMED Act.
Which provision?
Under section 18, my lord. May I take from section 15? Liability of the buyer to make payment. That's section 15, my lord.
Yes.
15 is the liability of the buyer to make payment. Then 16 is the date from which the rate at the interest is payable. 17 is recovery the amount due. 18 is reference. In reference to such an institution or center for conducting conciliations and provisions of section 65 to 81 of Arbitration and Conciliation Act 1996 shall apply to such dispute as if the conciliation was initiated under
So how
part
could
3.
you invoke this? Section 18?
Section 18, I invoke for non-payment of my dues, which was due under section 70.
No, but whether did you have the qualification?
My lord, my case is that I have filed the memorandum in 2015 and for the service I rendered between 15 to 18, I have gone to the council to recover the dues.
Oh, the chapter 5 deals with delayed payment to micro and small enterprises.
My lord.
So micro and small enterprises as defined under the Act?
Yes, my lord.
Where is that?
My lord, that's in the definition. Small enterprises is 2M.
Yes.
Means enterprises classified as under and subclause 2 of clause A of subclause 2 and
your
subclause.
Liability, sorry, your claim.
Yes, ma'am.
Is by virtue of section 15?
Yes, my lord. Yes.
And for section 15, you are required to establish that you are supplier?
Yes, my lord.
Now come to subsection N.
Yes, ma'am.
Of section 2.
Means an enterprise is classified as under subclause 2 of clause A or
N.
M, my
Supplier, supplier.
N.
Supplier.
Supplier means a micro or small enterprises which has filed the memorandum with the authority referred in subsection clause 1 of section 8 includes so and so. So here the memorandum has been filed in 2015 and the
Therefore,
for the period 2010 to 2015, you were not supplier.
No, my lord,
Admittedly.
admittedly. The
So
question
your
now,
claim is only.
I am
after
claiming
15.
only 15 to 18. So, and that is the court, the Honorable Single Judge held that it is not maintainable. Now, this has been answered by the Honorable Apex Court that this is a jurisdictional question also required to be decided by the tribunal, by the MACFC Council. All these matters have been referred. I've given a bunch of judgment. I'm passing it.
No, but whether those judgments were available before the learned single judge?
My lord, it is came afterward.
It came afterward.
Afterward. Because the order is dated, actually at that stage it was referred to, subsequently it came. In fact, there was a Delhi High Court judgment, and on the basis.
Where is the finding recorded by the learned single judge denying your claim?
My lord, may I just please. Paragraph 9 on the argument. Shanti conductor supra in interpreting the 1993 Act to be the beneficial legislation and subsequently repealed in 2006 was delivered by a stronger bench than Silpi Industry and Vaishno Enterprises. However, it is not on the 2006 Act. At Vaishno Enterprises was delivered after Silpi Industries and referred there in that Vaishno Enterprises, the court also left the question whether in a contract supply between the foreign, I am just leaving the foreign buyer and an Indian buyer, the 2006 Act would be applicable in view of subsection 4 of section 18 to be decided in the appropriate case. This court will not venture to take in view in situation the contract entered into in 2010, the supplier having obtained registration 5 years thereafter, and the supplies whether or not subsequently made. Mr. Ratha draw attention to the rejoinder filed by the petitioner, wherein there is a mention that on 10th May 2018, mechanical completion certificate in favor of the opposite party was issued. Regarding the objection on the composition of the council, now that's the second issue. So on paragraph 10 is actually, it says that because my registration is 5 years after, and the second issue, it has held that there is a 4-man council, 4-member council. The Honorable Single Judge has noted down that Vaishno Industry, I have given that judgment once, the Lordship can have. Straight away, I'm taking to that judgment at page, Vaishno Industries at page 67 to 71. I'm drawing your Lordship's attention to the page 70, paragraph 16, madam. May I please, madam?
Based on Silpi,
My lord, Silpi, it has said that
is
these
the
questions remain open.
that is the basic judgment.
Yes, but even subsequently now, 3 judgments come, all these reference has been answered. That all, so you know. Here, my lord, may I place paragraph 16?
Yes.
The question with regard to that, whether that prospecting application of registration is a question in the Boisno judgment, which has been relied upon by the Honorable Single Judge, has been left open for consideration by the larger bench. And I'm placing that paragraph 16, the way exactly the Honorable Apex Court has said. However, at the same time, the larger questions and issues, whether in a case where the buyer is located outside India, what has availed the service in India or done the business in India with the Indian supplier, and the contract was executed in India in MSME, would be applicable or not. And now, my lord, the second one. And Roth, another larger issue that in case the supplier is subsequently registered as MSME, the council would still have jurisdiction, are kept open to be considered in appropriate case bearing in mind section 18 as well as section 8 of the MSME Act and the judgment of this honorable court in Silpi industry and so cases, in which case similar provisions of under small scale industry and undertaking came up for consideration before this court. Now, my lord, I'm taking to that judgment, the subsequent judgment, larger bench judgment, that your lordship find out that it starts from page 72 and at page 88.
Para 33.
Yes, madam. 33 and 34. 34 VI is the answer.
The summary.
Yes, madam. 34 VI is the summary. May I just test? A party who was not the supplier, as per the definition contained in section 2N of the MSMED Act, or on the date of entering into the contract cannot seek to obtain subsequently this cannot obtain to take any benefit of the supplier under the MSMED Act. If the registration is obtained subsequently, the same would have effect prospectively and would apply to the supply of goods and rendering of service subsequent to the registration.
That's why you are saying that it
Yes.
will be from 15 onwards.
15 to 18.
So where is the decision of council? Council rejected your claim.
No, my lord. Council, it is pending. Again, I have gone to the council. I am the supplier, I have gone to the council. Now the buyer came up before this honorable court questioning that proceeding. And that was quashed, for against which I have referred this appeal.
You should not. Other side is appearing.
Yes, my lord. They have appeared and the delay was.
Now notice has not come.
No, notice has gone. My lord. They have appeared, delay, condone, everything is done.
Who is appearing? Who is appearing for the other side?
Kushal Hussain.
JP Behera, my lord.
This is Mr. PK Rath.
No.
Senior counsel.
No.
Ibrat Rath and
No. That government. That next. That Purbo matter. Jyotirmaya Prasad Behera.
Right.
Siddhartha Samant.
And Siddharth Samant.
All right, please inform him. We will take up tomorrow.
He was asking that Mr. Behera was asking me when it will be. I am just telling him that I think he's also.
So he has kept his agents in all the courtrooms. All right. There is no representation on behalf of the respondent. Heard. There is no representation on behalf of the respondents. So list this appeal tomorrow.
Okay.
Mr. Rath, take back that tomorrow on the date of hearing you. Otherwise, it will be misplaced.
Item 27.
No, 27 is that work charge employee. My lord just told that there is a full bench judgment of Patna High Court.
Yes.
And I have a look at it and your lordship may call it some other day, Tuesday or Wednesday, subject to your lordship's convenience.
Well, I also prepare a small note because I do not know the Patna judgment. Here is a case.
No,
where-
Patna judgment may be different. There the question was whether those who were on work charge establishment would be entitled for pension with effect from their initial engagement.
That is within our pension rule itself, my lord. Once they brought to regular establishment, our pension rule statute says they are entitled for entire. That is different, my lord. Here is a case where we have been brought to worker establishment with effect from 93. The state government undertaken to regularize us. In the year 1997, they brought a resolution. Thereafter, they attempted to retrench us. This court quashed the retrenchment order. Thereafter, the present impugned order by the single judge in terms of our own High Court judgments that if they should be brought to worker the regular establishment. That is the case before lordship. Not that whether the previous period will be counted. So I also small note I will prepare for lordship because Supreme Court judgment is also not enclosed in this writ appeal.
So please do it. When will you do?
Supreme Court judgment is not.
When will you do that?
My lordship, give me a 7 days time or 3-4 days time because I have to instruct the client 4 people. They are not able to come. My lord, give me 7 days time, my lord. Very poor people.
There are 3-4 matters. Let us make item 27 as the lead matter, subject to my learned friend. Agree.
27. So list as jointly requested on behalf of the party.
On item 27, there is item sub-item 2. If your lordship should consider, my lord, this is State of Orissa versus Balabhadra Naik. If that can be the lead matter.
We will, at the time of hearing, we will
Grateful.
take that.
Even the division bench of the Supreme Court directed in 1 or 2 cases to give pension and bring to them regular establishment. That I told before lordship, my lord.
All right, we will follow that. That is
40 years we have completed.
all right. This is matter on. Any day.
Grateful.
All right.
To be taken up at 2.
2 p.m. madam.
To be taken at 2 p.m.
Grateful.
Okay.
Item 28.
Item 18, madam.
Can it be some other day? All my juniors are saying that 27, 28 is a long holy vacation. So
Any day as desired well by him.
can be before, my lord, can be 21st, 22nd, any day or thereafter.
21st, I am in difficulty.
Then, my lord, let us have it after first week of April.
My lord.
2nd of April.
2nd of April.
As your lordship please, and as desired by my advocation number.
Grateful.
Pardon, Lordship, item 26, Lordship. I am opposite party number 1, Lordship.
It's coming tomorrow.
It will come tomorrow. You are not there when the matter was called.
Pardon, Lordship, pardon, Lordship. Lordship, allow 1 week time to file reply to the writ appeal, Lordship. In course of day, I will file.
No
Lordship.
reply is required in writ appeal.
Item 18, my lord. Your lordship.
Writ appeal, Mr. Counsel, no reply is required in writ appeal. Yes.
Item 18, your lordship just submitted that after 27 it will be taken up. Your lordship may fix it to same date so that it can.
I beg to pardon, my lord.
And if I not solve it,
My lord, I beg to pardon, my lord.
Your case will come on 3rd April, Mr. Counsel.
My
I beg to
Well,
in the meantime, similar numbers are.
in
I
the
beg to
writ
pardon, my
appeal
lord.
has,
Item 28.
ultimately the writ appeal has filed after 1 year. In item 18, the state has filed the writ appeal after 1 year of the judgment. That is why they want to tag both.
My lord, item 28. I will also kindly take it out Tuesday.
Yes.
In the meantime, my lord, if my lord permit me, I will give the supplier the similar cases to be taxed in 27.
Yes, you can give.
I beg to pardon, my lord. I beg to pardon, my lord. Item 28.
28, let the matter be called.
So I will also can take note Tuesday. Hold.
Item number 23 fixed for 2 p.m. hearings. Item 23.
You have to make a, if you have to make a mention in the morning, not in the middle.
Sorry, ma'am.
Item 23, I have something to, the second matter, WPC 19875 of 2019. Last week, kindly look to the order dated 24/8/2023, order number 21. In fact, this is a matter which was heard by the then Honorable Chief Justice and Division Bench Justice Adam Roth. And the judgment was concluded, the argument was concluded, and the extensive hearing was made. But the judgment was reserved on 24/8/2023, and somehow judgment could not be delivered, so it has been delisted. Then it has come now for a hearing. 24/8/2023. All these batch of cases, 19875 of 2019 and batch.
Order number 21.
Order number 21.
Yes.
No. But it has to be now reheard. That's the
Yes.
yes, ma'am. But here is the case. In fact, I have prepared a chart for you. I've given that a list of dates filed on behalf of the petitioner in that case. WPC 19875 of 2019. Is arising out of a judgment passed by a tribunal, state administrative tribunal. What has happened? So far as the present petitioner are concerned, there was a gradation list way back in 16/10/2007. On the basis of that, that is the select list which was prepared. On that basis, promotion was given. Promotion was given from time to time. But that promotion was the subject matter of challenge before the tribunal by some persons, those who are not selected. Not selected, they challenged before the tribunal. And the tribunal dismissed their applications. That what I've narrated in my list of
the post.
The post is fire. This is
Assistant Station Officer.
Assistant Fire Station Officer. Assistant Fire Station Officer. Assistant Station Officer.
Assistant Station Officer.
Station Officer. Fire.
This is promotional post.
This is a promotional post.
Yes. What was the dispute?
The dispute is a select list was prepared on 16/10/2007, and that select list, sir, can I give to you a
16/10/2007.
Yes, sir. Then on I prepared a chart for you, just background.
Yes.
13/8/2007, a letter was issued by the DG Police for filling of the vacant post of 13/8/2007.
So you said seniority list was prepared on 16/10.
But I'm reading the date chart, date of event. Yes. 13/8/2007, a letter was issued by the DG Police for filling of the vacant post of Assistant Station Officer in Orissa Fire Service by way of promotion as per Rule 660A of the Police Manual. That is at Annexure 1. Then 16/10/2007, a gradation list / select list was published for promotion to the rank of Assistant Station Officer In the said gradation list, name of the petitioner found place are serial number 169, 174, 184, and 195. That is at Annexure 2. Then on 24/10/2007, an office order was issued by the Director of Fire Service of Odisha giving.
So these are the petitioners. These are the petitioners, 169.
Yes.
174.
Yes. In my case, these are the petitioners. My learned friend, Mr. Mahanti's case, that was number 1 first case.
Yes.
And other batch of cases, their serial number is different. In my case, this is the serial number.
Who are they? Can you tell us?
Can you say? Mr. Mahanti? Yes. Serial numbers kept something. Let us list.
That part of the annex.
The first case, that is serial number 170. First case.
WPC.
WPC 30991.
%.
13 petition, 25 numbers.
13 petitions.
Yes.
All right. So just give us the.
Yes, the position in the gradation list.
The position.
The select list. Yes.
Then what happened?
Then on 24/10/2007, an office order was issued by the Director of Fire Service of Odisha giving promotion to 20 number of candidates from the rank of fireman and Havildar to assistant station officer out of the select list dated 16/10/2007. That is Annexure 3. On 2/9/2010, a letter was issued by the Director of Fire Service at Home Guard, Odisha, to the IG of Police personnel seeking clarification as to whether the select list is valid for 3 years or till it is exhausted. Then on 11/11/2010, in response to the said letter.
So you do not figure in this 20 number of candidates?
No. 11/11/2010, in response to the letter seeking clarification dated 2/9/2010, the IG of Police Odisha clarified that as per the procedure laid down in PMR 660, in order to be eligible for consideration of promotion to rank of ASI, a constable who have had 7 years of service after the period spent under training are required to pass in the written test as required under clause C of PMR 660.
No, but why was this communication required? Once this
Because there was no statutory rule so far as the validity of that list is concerned.
No. My question is that when this select list was published of 20 persons.
Yes.
In 2007.
No, that is not 20%. That is
20 number of candidates.
Out of those 20 persons were given promotion.
Or 20 persons were given promotion.
Yes.
The rest of them were not given.
Right.
All right.
So that is why this clarification. Then let's kindly come to the next page, sir. 21/10/2010. That is after 3 years. More 107 number of candidates were given promotion to the post of assistant station officer out of the select list dated 16/10/2007 after 3 years of publication of the select list. That is Annexure 6 at page 33. This is on 21/10/2010. And subsequently, again on 10/11/2010, another 18% of number of candidates were promoted to the post of assistant station officer out of the select list dated 16/8/2007 by the DG and IG of Police. That is Annexure 7 at page 37. Then 19/12/2014, some of the candidates who did not secure 50% of the qualifying mark in the pre-promotional test filed OA number 516 of 2012 and batch of the original application before the Ronet Tribunal, challenging the criteria of fixing 50% of the qualifying mark of the written test held in the year 2007. The said original application were dismissed by the Ronet Tribunal with a finding that 50% of qualifying marks for filling of the post of assistant station officer cannot be faulted with. Further, while dealing with the case of the said applicants, the Ronet Tribunal made an observation at paragraph 9 of the order regarding the validity of the select list. Then on 21/9/2015, challenging the judgment dated 19/12/2014 passed by Law Tribunal, the applicant in way number 3748C of 2014 preferred writ application bearing WPC number 16027 of 2015 before this Honorable Court, and this Honorable Court upheld the judgment of the Law Tribunal with a finding that writ petitioner have not implemented the person like us who have got promotion out of the select list dated 16/10/2007 as they are necessary party to the case. Then on 26/2/2015, a letter was issued by DG of Police for conducting the pre-promotional test again for the rank of Assistant Station Officer. Then next page. Some of the selected candidates, like the petitioners, whose name found place in the select list of the year 2007, filed original application before the Law Tribunal with a prayer to quash the letter dated 26/2/2015 and give them promotion out of the select list dated 16/10/2007. On 24/6/2015, the Law Tribunal quashed the letter dated 26/2/2015 and directed the authority to act upon the select list dated 16/10/2007 to consider promotion of the appellants of the original applications. Kindly see annexure B/3 at page 30. Then 1/2/2016, implementing the order dated 24/6/2015 passed by the Land Tribunal in way number 751C of 2015 and batch of cases, 34 candidates, including the present petitioners, were selected for promotion to the rank of Assistant Station Officer and were directed to undergo ASO course of training for a period of 4 months. That means on 1/2/2016, pursuant to the judgment of the tribunal, and where we were selected and we got promotion and we are allowed to go to undergo this training, which is requirement precondition for the promotional post. Then on 26/7/2016, the petitioner were declared to have passed and qualified in the ASO course of training, completed the training and they are declared to have passed. Then WPC number 13566 of 2015 and batch, some unsuccessful candidates who are not parties in the original application approached this Honorable Court challenging the order dated 24/6/2015 passed in way number 751C of 2015 and batch without implementing the present applicants in the original applications, and the person like the petitioners who have already passed the ASO course of training, Assistant Station Officer course training, in terms of the order dated 24/6/2015 passed in way number 751C of 2015 and batch. Then on 6/7/2017, this Honorable Court, of course a division bench, passed a judgment in WPC number 13566 of 2015 and batch directing the state government not to give any promotion from the select list of 2007, thereby adversely affecting the petitioner as they have already underwent the ASO course of training and were given promotion in terms of the order passed by the Land Tribunal. So this order of the division bench, because we are not parties to that writ application, but the order was passed in our, not only in our favor, we are given promotion and we have already undergone the course of training. So we are necessary party, we have been adversely affected by the order of this Honorable Court, but we have not been implicated as party and order has been passed. So therefore, we have filed this writ application. So far as my case is concerned, I filed this writ application, keeping in view that judgment of 2006 Supreme Court, as your Lordship knows, that if a person is not implicated as a party and order has been passed affecting his right or adversely affecting his right, instead of filing a review application, he can file a independent writ application to recall that order. That Polasin case was first. And applying that principle, this writ application was filed. Your Lordship also passed some interim orders. And the question is this, Your Lordship, may kindly, before I take Your Lordship to the interim judgment.
So the order was passed by whom?
By my Lord, both the judges are both the judges have retired. My Lord Justice Madam Ponda and Madam Justice. So now the question, if Your Lordship look to the death chart, I'm showing Your Lordships that that two promotions, one promotion is.
So what is the reason assigned by the?
Sir, reason is this. Here, yes, Lordship.
Where is the judgment?
Judgment is at page 44. Starts page 44.
46 is the big.
46, yes. 46 for
judgment starts.
Judgment start. Yes. May I take your lordship to the reasoning why it was lordship?
Seeing from different judgment.
Second case. WPC 19875.
Oh, just one.
46. Unaccepting.
Yes. If your lordship will come to page
Mr.
57.
Radha, please.
Sorry.
Yes.
Sorry.
So what is the reason assigned?
Reason at paragraph 11, page 57, running page 57. We, after going through the order passed by the prosecutor,
Yes.
we, after going through the order passed by the tribunal, have found that the tribunal has given no finding with respect to the legality and propriety of the instructions dated 13/8/2007. According to us, and in view of the admitted position, that there is no required recruitment rule governing the field. Hence, in the absence of the statutory rule, the authority has power to formulate the guideline by virtue of the executive instruction. The same has been done by the competent authority of the Fire Service of the state of Orissa by issuing a letter dated 13/8/2007, providing the provision and process of selection as assistant station officer. This 13/8/2007 was issued by the DG and IG of police, not by the government. We have also taken into consideration the legality and propriety of promotions having been granted, taking into consideration clause 5 of the letter dated 13/8/2007. The selection process since been initiated in the year 2007. The validity of the select list prepared on the basis of the said selection process would be valid for 3 years, that is up to the year 2010. We are making this observation on the basis of the fact that the validity of condition of number 5 of the letter dated 13/8/2007 has not been questioned. However, we have already expressed our view that even the select list cannot be said to be valid for a period of 3 years or till the framing of the cadre rule, whichever is earlier. But this is the very important. But since the government has given effect to the letter dated 13/8/2007 and the employees have already been granted promotion in pursuance of the same, we have also got the promotion. Hence, we are not expressing our views regarding the promotion already granted, but next these 3 within the period of 3 years, as has been decided under condition number 5, the letter dated 13/8/2007. But fact remains, if you also look to the date chart, on 2 occasions, after the expiry of 3 years, because they have given promotion on 21/10/2010, which is annexure 6, and on 10/11/2010, they have given promotion under annexure 7. 107 number of persons have given promotion on 21/10/2010, and 10/11/2010 were given promotion. 18 persons were given promotion. So far as we are concerned, we are giving promotion after the judgment was passed by the tribunal, that is on 1/2/2016. And this judgment was pronounced on 6th July 2017. Of course, the earlier the division bench where the matter was heard, my lord, state supported this. State also filed the counter in our case. All the cases supporting our case. That is also that is a matter of records. Sir, only this within a period of 3 years. That means you also can ask that question, which was also posed by the honorable bench, that if you have given promotion to 107 persons on 21/10/2010, that is after expiry of 3 years, then on 10/11/2010, if this person within the period of 3 years will be deleted, then everybody, there will be no problem for anybody who have already got promotion by virtue of this judgment. We'll also come to the next page. Next page. The operative portion of the judgment. Para 2. The state government would not grant any promotion from the select list prepared on the basis of the select.
What is the stipulation in letter dated
13/8/2007? Yes. Kindly come to that. That is at page 20. That is at page 20. I will counter that.
And in that case, these are
yes.
in that case.
Yes. You have to get it at page 20, annexure 1, 13/8/2007. This has been addressed. IG of police has addressed this letter to the fire officers. Subject is promotion to rank of ASO in Orissa Fire Service. Sir, these are the 1, 2, is the, I'm reading from 2. A pre-promotional selection test is to be conducted with the following subject. 1, test of technical knowledge. Then 2, English and Oriya translation. Then 3, if more than 200 candidates offer their willingness to appear in the pre-promotional test, we may hold examination at the range headquarters simultaneously, which is permissible under PH rules, so and so. Then next one. The minimum qualifying mark is fixed at 50% to be secured in each subject.
No, but what about 5?
5. This 5 pillar, that was the this is not a neither a rule nor an executive.
May not be a rule.
That's it. That is what they have done. The IG of police, they themselves have given promotion after expiry of 3 years, not only 210%, but another 18% from time to time after expiry of 3 years. And that is why they sought for an clarification from the. And your lordship had in the order, of course, that is a judicial order, directing the opposite party to take instruction to produce the records that if you have given promotion to those 210 persons after expiry of 3 years and in absence of any statutory rules, then why the petitioner who have already got promotion by the time the judgment was passed, why they will not be protected? That they had produced certain records before this honorable court, and after verifying that record, your lordship, that bench, honorable bench, has reserved for the judgment. And throughout the entire in the earlier writ application for the tribunal, the state has filed counter supplementing the case of the present petitioner. That is different. That's it. So this is the entire. If the 3 years now, if your lordship will say yes, from henceforward, from the date when the judgment was passed by the division bench, no promotion will be given, all right. But promotion which have already been given, so far the present petitioner are concerned, they have already undergone the course, already completed.
But if the promotion was illegally granted.
Sir, no. Now the question is that IG and DG of police, whether they have the authority to issue any circular, that you also kindly see that is subject to approval.
No more res integra.
That is also
given answer. May I assist me?
Yes. Have you completed?
Yes, no, my lord.
I'll supplement here. I'll assist your lordships. In the fire service organization, they had no recruitment rules. It expressly says that it will depend upon police manual rules framed under the Police Act. Police Act says that DG police can frame some rules, but subject to approval of the government. Let us take that this advertisement, which was placed before lordships that 3 years, that never had the back of the approval of the state government.
That is not a rule.
That is that executive instruction.
That was
Instruction issued by the director, if he can, subject to approval of the state government.
No. For this, there was no approval was required.
That is required under the Act. Under the Act, it requires that any instruction given by the DG police can formulate, but subject to approval of the state government. That is what the statutory requirement. And that point has been answered by your lordships in this court by examining that such a condition, whether it is 50% to pass or 30% mark required for passing, that also requires an approval of the state government. That point, I'll address your lordships. A judgment of your lordships followed for last 20 years says that state government should give the approval.
Please come to the last but one paragraph of that communication.
Yes.
Dated 13/8/2007.
Yes.
And page 21.
Yes, ma'am. Yes, ma'am.
List of willing. So you were willing. List of willing firemen, loading firemen, whatever, driver.
Leading fire.
Driver Havildar.
So you were willing.
Question is,
You were willing.
this letter is addressed to the superintendent of police.
Just complete.
Minors.
You were willing in the light of the communication issued by the Office of the Director General.
Minors.
paragraph 5 of it specifically prescribe that the term of the select list shall be 5 years to 3 years.
Minors.
How can you?
This follows Police Manual Rule 660. 660 says that such of the constables who have completed 3 years of service may be asked to appear in the departmental examination for being considered for further promotion. Such of them who are willing may appear in the examination. We appear in the examination, and if we qualify in that examination, we are considered as qualified constables. Once qualified constables are panelled, as and when requirement is there for a promotion, they are called to Central Selection Board. The Central Selection Board selects among them, among the qualified, those who have qualified, and then sent for training. And in the training, if he qualifies in the examination, according to the result of the training, they are arranged and given appointment.
The import of this letter is that the select list will lose its force after 3 years.
That is what I
After 3
say.
years, no appointment could have been made.
After 3 years, could not have been made. They sought a clarification from other departments. Then those who are control of the rules, they asked for a clarification. They clarified that there is no time limit for these. Why? Why? Your Lordship will ask question, why? A select list cannot live for all the time. This is not a select list, I beg your Lordship. A qualifying examination. The ordinary constables become eligible to promotion after 3 years. Then he is to face a written test called qualifying himself. He qualifies in the examination and his name remains in his own constable list as it is. It's not a select list. It's a qualifying list. By using the word selection, a confusion has been crept into the previous judgment, which we are seeking review. Minors. This qualifying constables, minors, will go before. I'll take your Lordship the rule 660 of the police manual.
Just a minute.
That judgment which we are preparing.
Select list select list तो चिन्ह देवा कोई थी ये select चिन्ह देवा कोई थी ये select
See,
my lord,
it does not say paragraph 5 does not say select list. It says the result of pre-promotional test.
my lords, that's what I say.
Shall remain valid.
That test,
Results shall remain valid.
the test, that is the confusion. The test is to find out qualified constables. Then from out of the list of qualified constables, a selection board sits very senior officers. They examine the CCI, health condition, and then select. That is the select list. So the word selection has crept in.
Select list is not there.
Not there.
It is the result of
that the test. Minors, I'm obliged.
It does not refer to select list.
Original rule, my lords, original rule to which they want to follow. The opening letter says, following the 6 rule, do not have any time limit for that to find out what happens. A man is entitled to get a promotion or a recruitment provided he is a graduate. He is required to pass a graduate examination, a degree with him. He doesn't require to appear each time a degree examination to be qualified for that test. So this is a qualifying test.
So this example you gave, we are giving another example.
Minors.
All right.
Entire government machinery, now, my lords.
Just a minute. The University Grant Commission has a provision for holding national eligibility test.
Yes.
And if someone qualifies in that test,
only is eligible.
JRF, and if he gets registered, within particular year, then only, because that.
Then only he
result
can
is
go
only for
become a
that
lecturer,
purpose, otherwise he'll have to appear again.
assistant professor.
And this is international practice, not for every test. A result of test is valid for 1 year or 2 years. After that, if someone wants to have the benefit again, he'll have to appear again. So that is the practice. This is not
The
something
practice
new.
here demonstrated
This
before
is
your
not
lordship,
something new.
the practice demonstrated before your lordship is, they did not stop at the end of the 3rd year. They sought clarification.
The question, simple question is whether clause 5 was validly entered in the letter or not, or whether.
I will only beg your lordship.
That is the only
Yes,
question.
I will only beg your lordships that this notification has been issued in exercise of the powers conferred on them under Rule 660.
Disturb, you are not challenging an order passed by a writ court. You are seeking review of an order.
Minors.
A recall of the order.
Minors.
We may not be required to go into those aspects. Those aspects shall be considered only if.
It has not been considered. My lords, that has not been considered. I'll beg your lordships. I was not before the court. My lords, I was not before the court when the orders. Minors.
This writ application is in the nature of review in the light of that Supreme Court's decision.
Minors.
Is it not?
Yes, ma'am. I was not before the court. I was not been heard. That's why I'm before your lordship.
Fine.
Minors. And not only that, had I been there before your lordships on that day, what I would have answered your lordships, I'm trying to reach there. So question is, my name was in the select.
For the other side. But the notices were issued.
No.
Notices were issued to the private respondent.
Yes.
Private respondent there.
I am 49 and 10.
No, who are the writ petitioners?
They have not appeared.
19875, 2019.
They are opposite parties. Number
They were
6, 7, 8.
disqualified totally.
Total
They were disqualified, not at all their name in the list. My lord, we have made
Sir,
them
I have in my writ application, I made them parties.
We have made parties.
In the first case, there is no private opposite party, madam. And in the
No,
second
I'm-
case,
Mr. Misra, Mr. Rautra is pressing his case, that second item.
Madam.
He was arguing that.
No.
19875 of 2019.
Yes, ma'am. There are private.
There from opposite part number 6, 7, 8,
Yes.
9, 10.
Yes.
And 11 to 14 are read as form of.
Yes.
Whether notices have been issued to them and
Say, coach.
I am appearing for 9 and 10. OP 9 and 10.
Yes, because my senior is appearing for opposite 910.
9 and 10.
9 and 10 you requested and
Yes. Second read is concerned.
on 3/4/2023
It's a notice.
on your own appearance
Yes.
you have taken notice.
Voluntarily appear କରିଛନ୍ତି.
He appeared so much.
So much.
9 and 10 Mr. Patnaik is appearing.
Yeah. I cannot boldly say, but you know, kindly verify. I don't think that notice has not been issued. They have appeared voluntarily.
My lord, may I kindly see the order dated first order, 1/10/21.
Notice issue.
1/10/21.
Madam.
देखिए what देखिए. ମୋ କେସରେ ଦୋଷ ପାର୍ଟି କରିଛି ନା?
ହଁ ହେଇଛି ହେଇଛି ବାବା କାହିଁ ଶୁଣିକି ଆସୁ ନୋଟିସ୍ ହେଇଛି ପର୍ମାନେଣ୍ଟ ଫାଇଲଟା ପଢ଼ୁନ ମୁଁ ପଢିଛି ନା ମଗେଇକି ରେକର୍ଡଟା ଦେଖିବାକୁ ରାଜି ନାହିଁ
Now only 9, 10 you have been appearing Each time you have been appearing and some orders are passed
Yes,
for you.
yes, ma'am.
18/3/2021.
Yes. Yes.
Was in 19875 of 2019.
Yes, in my matter.
Yes. It's the main case.
Yes, issue notice to the opposite parties through registered post with AD. That is on 18/3/2021, order number 5. Who are the petitioner? They want to petition. In some cases. We get the kind ये जो रीड पिटिशन है वो उधर पार्टी तेरे पिटिशन ये जो रीड पिटिशन जो उधर अरेंज कर जो ऑर्डर था select list Yeah.
Where counter was
You
incomplete.
were the petitioners.
Yes, we are the petitioner.
How many petitions were filed? Were earlier not there. When the order came to be passed. By.
From three. Yes, madam, we are there. That our number is double P number 776. 15 and
From your PD.
Yes.
Whether those which petitioners have been included as parties in these cases.
No,
No.
that is our specific case that they are not included parties.
No, because you have included.
Yes, we have implemented.
We have.
Implemented.
So far as he is concerned, you have implemented.
We have implemented.
You have included, but you have-
No.
Yes.
No, no, no case is that. No case. No, no. Such a co case question करो.
We have made them parties in the case, main case, where the review has been sought.
रोज से को question
And other cases, we have joined by way of filing individual read petitions as co-petitioners. All these cases, all the parties of the previous judgment have been made party in the main case, in which Mr. Rautrai is addressing your lordships. All of them have been made parties. Only formally, we have joined by way of filing individual read petitions later, and these 13 cases have been minors. Yes.
Your writ petition has been tagged.
With this,
Not become a party to other writ petition. Your writ petitions are separate.
yes,
Are you not clear?
yes, my lords. What happened? Main case, all of us, some of us in representative capacity filed the writ for review. We have joined because the department went on filing, holding press examinations. We came before lordships in individual cases, and your lordship was kind enough to tag that case with this and state that further examination. When Mr.
This 19875.
19875.
That is the main case.
My lord. That is the lead case which your lordship have also heard.
We are not parties, not only that, many other points could have been examined by the court.
So there were how many cases? Please come to paragraph 1.
Paragraph 1 of the judgment in
No, paragraph 1 of the.
my reader. Yes. The present petitioner were adversely affected by a common judgment dated 6/7/2017, passed by this honorable court in a batch of writ application bearing WPC number 13566 of 2000.
Batch of writ application.
Yes, that is at page.
Those numbers are here before lordship.
Page 46.
So whether all these petitioners are parties.
Yes, my lord. They are all parties before lordship.
No. Just one minute.
25 petitions are there.
So, please.
Please.
Your lordship, kindly come to page 46. Page 46. Who are the petitioners in those writ applications?
That has been given there in the top of the.
Top of the page 46 top. 22716 Bhimsen Behra. 13566 Abhay Kumar Swami. 4494 Hare Krishna Mahaprabhu. Sorry.
Yes, page 46.
Yes. Let's see that WPC 22716 Bhimsen Behra in the top. Yeah, is the petitioner.
Oh, next is Abhay.
Next is 13566 Abhay Kumar Swami. Next is 4494 Hare Krishna Mahapatra. Then 776 Kailash Chandra Pradhan. Then 920 Akhil Kumar Sahu.
This much.
This last two is 9 and 10 in present leader.
Yes. Others are also parties.
Appeared. Vincent Behra, Abhay Kumar Swami. Mahapatra, they are here.
No.
All of them.
Except
9 and 10. This Kailash Chandra Pradhan and Akhil Kumar Sahu. I am for these two. 9 and 10. I don't know whether notice is sufficient with previously or not. I don't know.
register.
I do not know, but you came very late. I was in the court, I allowed you.
What is your submission?
My submission. Your Lordship, I can take your Lordship to annex 1. This, your Lordship, goes to annex 1. Page 2. Annex 1. This page is conducted for the vacancy.
No, that is the only question is.
Yes.
That the order was passed by this court in their absence. So they want recall of the order.
Yes.
What's wrong?
There are two submissions in there. To recall the order and give us promotion. Once
Your promotion we will consider later because they don't.
Once it is recalled, your Lordship will recall the order or review the order. Then again it will be heard. Without hearing, how could they get promotion?
What they are saying.
How could they get promotion?
They will get promotion or they will not get promotion, that is a different.
And throughout them, we are.
Can you dispute this legal position that they were required to be heard before their appointments were cancelled at your instance?
Well, your lordship says, see, I'm sure one would, unsure. This test is made for
We are not on merit.
Yes, sir.
You don't know what is the fate of that case finally. But they were not heard. It's an undisputed fact.
My lord, they have not heard. My lord, while 13566, your lordship say annexure 8.
Notices are served.
I have some submission, my lord, subject to my lord's acceptance. Now, this judgment of this honorable court was carried to honorable Supreme Court. That was dismissed. We do not see any merit in this special leave petition, which is accordingly dismissed. That SLP was dismissed. Now, to the first submission, my lord, that the persons who have been given promotion are not made parties. My first humble answer will be, they were never given promotion, ma'am. My lord, that will my lord see as my lords will go through the records. My first submission before this honorable court is that those persons were never promoted. Number one. Number two, my lord.
No, we are on a different point. They were not granted promotion according to you. They were in the merit list according to you. They were about to be given, so there was no right vested. But still, they were going to be adversely affected. There was a selection list prepared. That selection list has been cancelled before, without giving them any opportunity.
To that, I was submitting my second line. Now, by virtue of an order of the tribunal, in 2016, a list of 33 persons were considered by CSB. In this list of 33, all these petitioners are here, who are before my lord seeking recall or review. And those persons were not before the tribunal, my lord. By virtue of an order of the tribunal, my lord, those 33 persons were sought to be considered by the CSB, which the tribunal order was stayed by this honorable court, then quashed.
Therefore, whether they were required to be heard or not, that is the only question.
Yes, ma'am. Question is, when a benefit was given to them, was being considered in their favor by virtue of an order of the tribunal where they were not made parties. Now, that tribunal order having come here and having been adjudicated by this honorable court and having gone to honorable Supreme Court, having rested. So, my submission to this honorable court will be, my lord, they were not necessary parties. My lord, my fourth submission, my lord, is two writ petitions, my lord, will see. This, which my lord, my senior Mr. Rautra is, my lord, is doing the case number 2 case. It came before an honorable division bench. My lords have passed on order on 1/10/21, where my lords have said, Annexure 5, okay, you can participate without prejudice to your right. On the same date, my lord, 1/10/21, the first case, WPC, the first case in the list, 30991 of 21 was listed before honorable single bench. And in that, Annexure 5 was stayed. We are aggrieved there now. We humbly pray this honorable court.
Have you challenged?
Yes, my lord. We have filed for vacation of that order. And we humbly pray, my lord, since our division bench, honorable division bench has said, no, there was no stay. So that order we are allowed to operate. and we are unable to give promotion, my lord. A new rule has come into force.
Now, one more thing, my lord, 135. I say.
And rule is not on the challenge.
3 persons out of this 34.
No, when was your, when were the rules framed?
21.
21.
My lord.
11 years after that.
Yes, my lord.
My lord,
But these are the 4 things I have stated.
out of this 30, they are aware of this judgment and the filing of this judgment. Out of 34, petitioner serial number 7, 8, 9, 10, 11. 9 out of this 34, they have intervened in the matter, and they have intervened in the matter. After dismissal, they went to Supreme Court, and it is also dismissed. And the item numbers, this is 17, my lord. He has filed an independent writ application, which is also dismissed by the Lord Chief Justice. And this is annexure A/3 of the government council, Lordship. That judgment is there.
A counter affidavit in which case?
My lord, we have filed a counter affidavit in WPC 30991 of 21, first case, to be adopted in all the cases. So, my lord,
may I be
we have
permitted?
Please give us brief notes.
Sir, sir.
All of you.
Yes.
About the party position.
Yes,
at this.
yes.
It should be clear. In fact, if we recall the
Right, sir, right, sir.
in the absence of the persons, they will be taken
Right.
in the same
Well,
case.
if I've correctly understood your lordship's proposition, your lordship asked the question to the state council and to both the councils that whether the persons who are adversely affected, they are necessary parties or not, whether you have implemented the parties or not, and order has been passed without in their absence. And my learned friends, they argue, the state council, that they are not given promotion, therefore no right is accrued to them, and they were not parties before the tribunal, so they have no right. You also look to page 39. Whether a right is accrued in favor of these persons where they are required to be made parties or not, that will also be considered. Page 39.
39 of what?
Of the brief.
There are so many cases.
My second case, the main case, lead case. 19875, man. 19875 of 2019. Page 39, annexure 8.
Third line, the promotion what?
Just get it.
1 to 16.
Yes, sir. Yes, sir. Judgment was passed in 2017. It is order dated 1 to 2016. In pursuance of Home City Department letter 961 dated 5/11/2015, containing direction to implement the order of the Honorable Tribunal OAT Cuttack Bench Cuttack dated 24/6/2015, passed in way number so and so, for promotion to the rank of Assistant Station Officer in Odisha Fire Service out of the select list drawn in 2007 till its exhaustion. As such, CSB was convened, that selection board was convened on 19/1/2016 to assess the suitability of the candidates out of the existing panel of gradation list drawn during the pre-promotional test held on 23/9/2007 in order to fill up 34 number of vacancy in the rank of Assistant Station Officer by way of departmental promotion. The CSB scrutinized the nomination roll along with the service particulars of the eligible candidate and selected the following candidate for promotion to the rank of Assistant Station Officer in their respective category. Serial number 11 is Benudhar Behra, is the petitioner. Serial number 11.
We are all there.
And all these persons before your lordships, all are there.
So that it was not a promotion is not correct.
And how the state council can make such submission, if you lordship will look to the order in the very same case. Order dated 23/8/2023. Why your lordship asked them to file this affidavit. Throughout before the tribunal, they had supported that these persons should be promoted, they have got the promotion, that is their case. For the first time in this writ application, they have come forward and say in 2021 we have made a new rule. Now, in view of that rule, we should give them. That is the only question.
That is why court asked them to file another affidavit.
Another affidavit, 23/8/2023, also look to that order, order number 20. Mr.
Where is the provision?
616.
Well, for 3 years.
Till then, I will give a short note for your lordship's call.
Please give, otherwise
Yes,
this
yes,
is very
because
difficult.
I understand that there is some little bit.
Party
confusion.
position is very crucial.
Yes, sir, yes, yes.
Otherwise, we shall be committing the
Yes,
same.
yes, yes. You can, I bow down.
This case on 1 week. And please verify from the order sheet
Yes,
also.
sir. Yes.
Whether the notices that
How
was served or not.
composite it?
ফাইলটা দেখুন ফাইলটা
କରିକି ଦବା
ଦେଖିଦେବେ ଆପଣ ଦେଖିବେ ଯେ ଫାଇଲ କୁଆଡେ ଯାଉଥିବ ଆଜି ଆଗରୁ କଣ ଦେଖିଦେବେ ଫାଇଲଟା ଟିକେ
And
ଦେଖିବେ
please give us exhaustive list of dates. You also prepare because
Yes, sir. Yes.
we were not aware that you have also filed an application and there's some stay. So that way.
Yes. And so for the merit of the case, if I've understood correctly of your lordship's person, that merit, suppose your lordship.
No, there are 2-3 aspects.
Yes, sir.
One, there is one writ petition which seeks review. That is confined to that point only.
Right.
All right, because in your absence, the order was passed. But there is another aspect that there was an appeal preferred before the Supreme Court.
Sir,
Against the same order.
that also I can argue. Your lordship knows, even a review of, if this SLP has been dismissed at the stage of admission, review is also permissible before
All right, we will see.
I'll
So that is.
And that we have not filed. Somebody has filed
So
at the stage of SLP.
that is confined to that.
Yes, sir. Yes.
That writ petition is confined to that point. So once that is restored,
Yes.
the writ petition is restored, then probably the writ petitioners may also appear.
Right, sir. Right. You're correct.
So once that is restored, then
That is what you also wanted to know from them, that whether they had appeared despite notice and whether notice had been issued in that writ application or not. And these are the matters which must weigh in the mind of the.
And my lord, as far as state is concerned, because there was a direction to frame rules. So we have framed the rule.
You have framed the rules in 2021.
Yes, that the direction is went to Supreme Court, got confirmed, then we did it. And my lord, because of the interim order, we are suffering.
You are suffering not because of interim order.
We are not able
You
to
are
keep promoting.
suffering because of your own lapses. And we don't know whether you are suffering or not.
Only interim order.
Interim order to be continued.
Interim order, what is the interim order? Interim order that's not.
Subject to my lord's acceptance, may I say, my lord, there are 34 petitioners. My lord may keep 34 posts for them. My lord may allow us.
Let us see. The matter has remained pending for long. Let it be.
My lord is keeping to next week.
Next week.
Obliged.
Item number 28.
Your lordship adjourn it to 22nd.
No, 22nd, I am not here.
Your lordship, I was told that your lordship is from 28th. Yes.
27th or 28th.
27, 28, I am not there.
All right. And then April.
1st April or 2nd April, any day.
First
Second April. 2nd April.
3rd April.
3rd April. Okay. Obliged.
Item 28.
Well, item 28 is concerned. I will logically taken out Tuesday.
Tuesday, all right.
Obliged.
As requested, not Tuesday. It's already Tuesday. As requested.
Item 29.
এটা হ্যাঁ ভাই
এটা ওটা হিউম্যান Before I
before I take my lords to the merits involved here, let me just clarify the technical position. Thus, respond number 3 is in fact against whom the notice is stated to be not sufficient. Respond number 3 against whom there is a noting that notice is not yet, AD is not back. I don't think that respond number 3 is a very necessary party here, but it's the government of India. We have grievances against the NIT. So that can be dispensed with at the risk of the appellant.
Mr. Party is not accepting notice.
That we can serve a copy on him, but then notices can be dispensed with because they are not very much necessary parties.
We will see.
We have grievances against NIT and they are appearing. But subject to equality permits, we can serve a copy on him also.
Yes.
Now, the appellant is aggrieved by order passed by the Honorable Single Judge to the extent, not the entire order. Lordship sees the ordering portion, page 30 of my brief. Only to this Roman 4 portion, the appellant is aggrieved. Let me clarify the position below. Under the Sexual Harassment Act, there was an allegation against the appellant. Now that allegation was initially inquired into and it was dropped on the ground of Bardwell limitation and conciliation between the parties. Thereafter, another allegation by the self-same victim against the self-same assistant professor NIT, and that allegation was inquired into. Now the second allegation with regard to sexual harassments, all reported in negative. They were not proved. Only what was proved is that this appellant assistant professor informed about this victim to her parents. That is what was said to be established, which is not a sexual harassment within the definition provided in the 2013 Act. Based on that report, NIT dismissed the services of the petitioner. Now the dismissal order was challenged in a writ petition, and the ICC report, Internal Complaint Committee report, was challenged in another writ petition. Both the matters were taken up together. My lord, the Honorable Single Judge has considered the case to the extent termination was set aside, my lord. Am I clear, my lord? The termination order passed by NIT against me based on the second report was set aside by the Honorable Single Judge in the same judgment. So far as the Internal Complaint Committee, that report which are challenged in the other matter, the Honorable Single Judge has said that you go and prepare an appeal. But to that extent, I am aggrieved and I am before my lords. I have just prepared a small note for my lords.
So where is the appeal?
Beg pardon?
Where is the provision for appeal?
Yes, section 18 of the Act, Lordship will kindness. Lord, I have just prepared a small synopsis for my lords. Lord, I have section 13.
Yes.
Sexual harassment of 2013 Act. Section 18, my lords, kindly. Yes. Section 18. May I be permitted to please it now?
Yes.
Any person aggrieved from recommendations made under subsection 2 of section 13 or clause 1 or clause 2 of subsection 3 of section 13 of subsection 1 or subsection 2 of section 14 or section 17 or non-implementation of such recommendation may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules applicable to the said person, or where no such service rules exist, then without prejudice to the provisions contained in any other law for the timing in force, person agreed may prefer an appeal in such manner as may be prescribed. But first of all, let me tell your lordship that it says that the has to prefer an appeal under the service rules. Because provisions of the service rules applicable to the said person. But service rules for the NIT, for this assistant professor, I must bring to my lord's notice. What is that service rules? I would copy this. But service rules of this, the booklet I have handed over, my lord. Straight away, my lords may turn to page 49. That is folded, my lord, for my lord's convenience. Running page 49 of this booklet. That is 9 rule Rule 26 is the penalty provision. Lordship may straightway come to Rule 9, Sub-Rule 9.
Yes.
Any member of the staff aggrieved by any order imposing penalty passed by the director against him shall be entitled to prefer an appeal to the Board of Governors against the order, and there shall be no further appeal from the decision of the board. Then 10. Any member of the staff aggrieved by an order of the board inflicting a penalty on him shall be entitled to prefer an appeal to the visitor against such order. So what's the catch here is, my lord? It is only against a penalty.
No. Maybe against penalty, but it says.
But that too kindly similar. Member of the staff agreed by an order imposing penalty passed by the director against him. So it's unless a director passes an order.
No, it just defines appellate authority. Who shall be the appellate authority?
Yes.
Section 18 provides that only.
Right.
So when was this rule framed?
This rules, my lord, it was 2009 month.
2009.
Correct.
And this was enacted in
2013. Correct.
It just defines who will be the appellate authority.
Right.
And whosoever is the appellate authority under the service rules
So your lordship
shall be the appellate. That
your lordship may propose to say that even if it's an internal complaint committee's report, an appeal will lie to the Board of Governors.
So yes, in terms of this.
Even if it is not, to that extent, I can also accede, my lord. But one more point, if your lordship will consider, that section 18 says against which are those recommendations an appeal will lie. If your lordship sees again at the cost of repetition, my lord, those recommendations must be under subsection 2 of section 13 or clause 1, 2 of subsection 3 of section 13. But none of these clauses are recommended against me. If that your lordship sees that inquiry committee's recommendation, kindly see that recommendation doesn't qualify against any of these section 13 provisions. Rather, the report is in my favor. None of those allegations are established. Kindly see that. That report is part of the record before the rule single judge. For your lordship convenience, I am giving that.
But what is the effect of that recommendation?
But effect is the effect of the only recommendation is you'll also see that report. Kindly see. Kindly see that recommendation, Lord. Page Page 11 of that petition. Page 25, my lords may straightway come to page 25. One second. Let's see page 23, paragraph 24, findings. Lord, that is the single judge record I am giving for my lord's convenience. Because the lordship may not search it from record. That finding I want to show to my lord saying that it doesn't come under any of the provisions of section 13. So I did not prefer an appeal. Honorable single judge should not have directed me to go in appeal.
So don't file.
Lord, then there is an order.
What?
Giving me, saying that against that inquiry. What I am trying to tell is the honorable single judge should have considered the report on its own merits instead of relegating back to the appeal.
Those only such as, if that has any effect, it's a different
matter. That has an effect because that's the report that you
recommendation, the court will not go into the correctness of that.
Lord, kindly see this.
Yes.
Paragraph 24. Finding starts from paragraph 24.
Yes.
Each of these allegations pertaining to sexual harassment are reported to be negative, are not established.
You are at page 25.
I am at page 23 finding, last towards bottom of this page.
Twenty-three,
my lord, of this, the bunch of papers.
Yes.
Let's see towards bottom, paragraph 24.
Yes.
Following are the findings of the committee in respect of background complaints by so-and-so based on statements of witnesses and evidences. Now this A, the same is difficult to establish due to lack of witness and evidence.
Just a minute. You are at page 24.
23, then I am at page 24.
24 finding.
Finding, it's part of the finding.
Then 24.
Then 24, correct.
Yes. Yes, correct. Which part of 24?
Part of 24.
Finding.
Finding is, it is difficult to establish due to lack of witness and evidences.
Yes.
Then B also similarly, my lord. Beyond office hours, weekend, in another case, record of warning letter to Professor so-and-so is also available. Background point number 3, my lords may see, the para C, the same is difficult to establish due to lack of witness and evidences. Now D also, similarly, page 25, it is difficult to establish what might have happened with her during that period due to lack of eyewitness and evidence. Now E is the only thing which is said to be established against me. E, my lord.
Yes.
Professor Karak complained her father that so-and-so used to roam with notorious guys at night during undignified things, thereby trying to tarnish her character before her parents. The complaint has been established. This is not coming within any of those categories, my lord, if you see section 13, my lord.
Section 2.
Either 2 or kindly see, my lord.
So what is the effect of this finding?
This finding, my lord, they dismissed me.
Huh?
NIT dismissed me.
But that order has been set aside.
Now that is set aside. That has attained finality.
Then why?
My lord, on the latter part of that order, the Honorable Single Judge says that go and file an appeal against this.
Don't file.
Lord,
Or you file. Why should we go into that?
kindly see, my lord. Consequence is this, my lord.
According to you,
The problem is similar. Kindly see, page
No,
30.
any appeal, you can take this plea.
My lord,
He may. So consider that this
that
doesn't
liberty
fall
be
within
granted,
the
my lord. That
fold of this definition,
that liberty be granted and disposed of.
because this statute
Correct, my lord.
is
Absolutely
within
correct. I'm great.
narrow compass.
Yes, my lord.
So
Yes, yes.
this does not fall within.
Lord,
this-
yes, if your lordship permits me to file an appeal before the Board of Governors, Lord, with that observation, my lord, I will go back. My lord, why I am before my lords, if your lordship permits me, I can just show it to my lords. Subject to if my lords permits, my lord. Page 30 of my appeal memo, my lord. This is subject to, not relevant. It's okay. As your lordship rightly proposes, my lord, that will be okay.
The appellant. Is working as a professor.
Assistant professor. Assistant professor.
An assistant professor in National Institute of Technology bracketed NIT Rourkela. A student of the NIT, girl student of the NIT alleged sexual harassment, made allegation of sexual harassment against the appellant, which led to an inquiry conducted by the Internal Complaint Committee.
Internal Complaint Committee.
Internal Complaint Committee bracketed ICC. Oh, stop. A disciplinary, the ICC submitted its findings on of the ICC. Who is the disciplinary authority?
The Board of Governors.
The disciplinary authority, that is the Board of the Governors.
No. I'm sorry, Lord. I'm sorry. Kindly see, Lord. It is director of NIT.
No.
Punishment
not
order
the
is passed by the
disciplinary.
director of NIT.
No, that has been communicated by the director, but
Then-
the
then
disciplinary
how can that
authority is
The
the
appellate authority.
appellate authority is the Board of
Board of
Governors.
Directors.
So you are saying Board of Governors passed the order.
No. The director communicated the order of the Board of Governors.
Who is the appellate authority under the rule?
Appellate,
You are appearing for whom?
I am appearing for the NIT.
So please tell us who is the disciplinary authority.
That the disciplinary authority is the Board of Governors.
All right. Who is the appellate authority?
But the disciplinary authority is the appellate authority. As per the
Then it
circular.
has to be decided.
The sub
Then
rule
the
9.
announce. Beg pardon.
Sub rule 9, 56.
Sub rule 9 against the punishment.
Same
So far
applicable.
as the report of the
Yes.
ICC is concerned, the disciplinary authority is the appellate authority. So ICC report against. That is the central government circular. Provided they prescribe the rule before whom the appeal is to be preferred. I have given that circular, but perhaps I have not communicated to your lordship. In my note, I have communicated that. That's it.
So in that case, I'll become an MP for one. You will become judge of his own cause.
No. It is the ICC report has been submitted before the disciplinary authority, and the disciplinary authority will be the appellate authority. And that has been incorporated in the CCA rule also.
Disciplinary authority cannot be appellate authority. Can never be appellate authority. Why are you making this submission? Can disciplinary authority be appellate authority?
That is also in my mind.
Possible.
That is also in my mind, my lord. That is.
How do you say that
Your lordship, can you see this? The appellate authority, so far as the Sexual Harassment Act is concerned, the CCA rule 24, your lordship, can see the paragraph 24. The circular which I have given to your lordship, that has been incorporated in that.
Where is that?
That appellate authority.
What do you want to show on this basis?
That I am only to show before your lordship, lord, who is the appellate authority against the report of the ICC.
Where is that? Where is
That
that?
I have given in the note.
24.
In this note.
Yes, my lord, that circular,
Yes,
lord,
sir.
your lordship can see.
Where has
Under-
the circular been mentioned here?
That is also mentioned. I have also.
Where?
In that book also, that has been incorporated.
Please show us.
Your lordship, kindly allow me to, I will show that page. Okay. Let at page 94, my lord. This is the. It is there. Because, my lord, the employee of the institute will be governed by the CCA rule.
You have their own statute.
Not statute, CCA rule.
Where is that?
At page 94, your lordship. For the purpose of section 18(1). Of the xerox कर देता हूँ। Yes, yes.
And as I have shown to my lords, Rule 26 is suspension penalty disciplinary proceeding.
No, who is the disciplinary authority?
Here
according to you?
here they say it is the director is the disciplinary authority. Director. The director may place a member of the staff appointed under the institute under
There can be
suspension.
so much of dispute over this thing.
Kindly
Alright.
see.
Your lordship, kindly see the
Just
section.
a minute, let us
Yes.
see the rules.
Yes, ma'am.
Rule 26 straightway running page 47.
Non-teaching staff.
Page 47.
Right.
Yes.
The director may place a member or a staff appointed at the institute under suspension, disciplinary proceedings, so and so, so and so. Then penalty is under sub rule 5.
Thank you, Rich.
Then sub rule 9 against the order of the director, appeal to the
Right.
board of governors. And this is the special statute for the NIT employees.
Disciplinary authority imposed punishment of dismissal from
Right.
service.
Yes.
Which there were two writ petitions, right?
That were challenged in WPC 5175 of 2020.
The order imposing punishment of dismissal from service came to be challenged by the appellant by filing writ petition registered at WPC number
5175 of 2020. 5175 of 2000.
5175 of 2020.
Yes.
Stop. The appellant had also preferred a writ petition giving rise to WPC number 2244 of 2020.
20.
Questioning the finding of the report of the ICC the order is common, judgment is common.
Common judgment.
Where is that judgment?
That is
Judgment is yet.
not writ appeal, annexure 1 itself.
Annexure 1. Page 18.
Page 18.
Oh.
Page 18 of my writ appeal.
Just
Page
page
20.
18 of your writ appeal.
Your lordship will get that common judgment from page 20, running page 20 of my writ appeal.
Oh, where is the order of the single judge?
Honorable single judgment. That starts from page 20. Then operating party is at page 30, running page 30 of my writ appeal.
Yes.
It is
Where the finding portion of the learned single judge starts from paragraph 8. Paragraph 8.
Both the writ applications were taken up together and came to be disposed of by a common judgment, an order dated 26/9/2022. Stop. By the said order, the learned single judge passed the order of dismissal dated 21/2020 with a direction to the NIT to reinstate the petitioner in appellant in service. Stop. As regards the finding of the ICC, learned single judge observed as under paragraph 11, Roman 4. Stop. Aggrieved by that part of the order whereby the appellant has been asked to approach the appellate authority, the present writ appeal has been filed. Stop. Learned counsel appearing on behalf, learned senior counsel appearing on behalf of the appellant has argued that the recommendation made by the ICC cannot be treated to be recommendation made under subsection 2 of section 13 or under clause 1 or clause 2 of subsection 3 of section 13 or subsection 1 or subsection
or subsection 1 or subsection 2 of section 14 or section 17 of the Act.
Grateful.
And therefore, the appeal will not lie under the provisions of the Sexual Harassment and of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Oh, stop. Next. After having heard learned counsel appearing on behalf of the parties, we are of the view that the said observation made by the learned single judge does not require any interference. So stop. Certain disputes arose as regards who would be the appellate authority in terms of section 18 of the Act. Section 18 of the Act reads thus. So stop. It is manifest from the language of section 18 that the appellate authority for the purposes of section 18 shall be as per the service rules applicable to the said person who is aggrieved by the recommendation of the ICC. So stop. Our attention has been drawn to Rule 9 of Subrule 9 of Rule
Subrule 9.
26
Subrule 9 of
Rule
Rule
26
of
of
the statute
of the first statute.
of the
First statute of the National Institute of Technology.
of the first statute of National Institute of Technology, which reads as under. So stop. It is evident that under Subrule 9, any member of NIT aggrieved by an order imposing penalty passed by the director is entitled to prefer an appeal before the Board of Governors against the order and shall against Board of Governors. Full stop. In our view, thus, the Board of Governors is the appellate authority under the rules governing the service conditions of the appellant.
Correct.
So stop. Accordingly, he shall be treated to be the appellate authority for the purpose of preferring an appeal under section 18 bracketed 1 of the Act of 2013. So stop. Next, our attention has been drawn to the CCS to certain office memorandum issued by the Government of India
Yes, that I have given that.
So stop. Government of India referring to Central Civil Services bracketed classification, control and appeal rules 1965. So stop. in our view, the said office memorandum shall have no application in case of the employees of the NIT
No, sir.
who are governed by separate statutes as, yes,
No, sir. Because your lordship can see section 24.
yes.
Section 24, 5, my lord. Because they are governed by the CCA rule, my lord.
What is that?
That is general terms and conditions of service of permanent employees. 4. The employees of the institute shall be governed by the Central Civil Service Conduct Rules 1964.
Which institute?
That has been provided in that statute, my lord, NIT statute.
For the purpose of exercise of power under section 18 bracketed 1 of the Act of 2013, as the service rules of the NIT staff specifically provide for appellate authority.
That's
I'll make certain corrections.
definitely.
Yes.
Only for that purpose.
Yes,
CCA
yes.
rules apply.
Justice.
The NIT employees will be governed by the CCA rule, my lord. That
Just-
will be.
Just a little liberty to raise all these points.
It goes without
Yes,
saying
yes.
that the appellant shall have liberty to raise all the points before the appellate authority which had been raised in WP number. What is that number?
That is 2244.
Double two of 2020.
20.
This appellant stands disposed of.
The lordship may also observe that since the limitation provided 60 days, my lord,
It is
90 days.
also
So
made
that-
clear that if the appeal is referred within 30 days from today, the appellate authority shall keep in mind the fact that the appellant was pursuing his remedy before this court by filing writ application and the present appeal while considering prayer for condonation of delay.
Can I ask for little more indulgence, my lord? Little more indulgence. There is an interim order in my favor because the disciplinary proceeding and dismissal part. Let that order continue till this aspect is decided.
No, what is that?
None.
That there, my lord. The interim order in this writ appeal is there.
What?
My lord, that is, the interim order is no further steps regarding the disciplinary inquiry. My lord, there are two things. Disciplinary proceeding based on this report. So once the validity of the report will be questioned there, so simultaneous proceeding will prejudice me. So that protection is already there. So I request, my lords, let that continue till this aspect is concluded.
What the
Till filing
Honorable
of,
Supreme-
just a minute, till filing of the appeal, the interim effect of the interim order passed by
6/3/2023.
23, my lord. Order dated 6th of March 23.
the interim order dated
6/3/2023.
6/3/2023 shall operate.
So grateful.
Till you
But
file,
till filing of the
till
appeal.
filing of appeal only.
I can appreciate
Because my lord, there is a judgment of the Honorable Supreme Court, where the Honorable Supreme Court has held that once the ICC report has submitted, the disciplinary authority is free to initiate the disciplinary proceeding unless the appeal is preferred.
After all, he is my operative. Vassal, I go.
The appeal, since your lordship granting the liberty to file the appeal, so therefore the interim order will
But,
continue till the appeal is preferred.
All said and done, the scope of the allegation does not come in within the purview of that's
No, that is coming since your lordship already disposed of. So therefore, I am not bringing to that part of the report to your lordship.
we are not saying merits.
It is subject to the consideration of the appellate authority.
We understand so many things. We don't comment.
Item number 30.
Yeah.
My lord, I'm filing a written note, my lord, short note.
Your written notes is of how many pages? 13.
4 pages, some have given, my lord.
Very scary.
Writ appeal, my lord, in writ appeal, though no counter is required, they have filed a counter of more than 100 pages. Therefore, instead of filing reason, I filed a written note of them, sir, my lord.
Instead of filing what?
They have filed a counter affidavit instead of filing rejoinder, not necessary because in writ appeal, no counter is necessary, my lord. But they have, government has filed a counter, my lord, more than 100 pages. Therefore, I have, instead of filing rejoinder, I filed the written note of consent. Here the case. Simple point, my lord. When a dismissal order is set aside and matter is remitted back to the inquiry stage, whether the employee, what is the employee status of employee, he should be, at least he should be treated as on suspension and get the subsistence allowance, my lord. Here that part is silent in the Honorable Single Judge's order, and they are not giving the allowance, my lord.
That is the only point.
Second point, my lord. I begin the written note, my lord. Another point.
No, you were dismissed.
Yes, my lord. Dismissed dismissed 2014, my lord, without an inquiry. That order was set aside by the court, my lord, directing to initiate a proceeding, then take action, my lord. They initiated a proceeding, my lord. The Honorable Court directed to conclude the proceeding in 3 months, my lord. They did not dispose of the pendation, dispose of the proceeding within the period stipulated by the court, my lord. Month after, my lord, after conclusion of the prosecution witness, they concluded the proceeding, and before without giving opportunity to me to give an witness, my lord. Again, I approached then order of the dismissal order passed again, my lord. From a retrospective date from 2014, that order was challenged, my lord. The Honorable Court set aside the order, my lord. And again, without deciding what is the position from 2014 till the new dismissal, and during the course of, during pending of the inquiry, my lord, again remanded the matter to the inquiry stage, my lord. Inquiry stage of the, from the defense witness stage, my lord. From the defense witness, because the defense witness was not given opportunity, my lord. But in the, from the evidence itself, my lord, the from the prosecution witness, my lord, that prosecution case was demolished, my lord, because the entire case was initiated on the basis of a report of the principal police training college. He is that police principal, my lord, has not been examined, and that report has not been proved.
Where is the order of dismissal?
First order of dismissal, my lord, page 14.
So when was the order passed? Order of dismissal was set aside when?
My lord, order of dismissal passed on page 15, my lord. First it was set aside. On page 18 is the order, my lord. First order, my lord.
What is the date?
Page 18, date is 3/9/2015. Page, my lord, page 18.
3/9/2015.
15, my lord.
23/9.
Page?
Page 15, page 15, my 18, my lord. Page 18 of the...
Page 18.
Yes.
That is 23/9/2015 order.
Yes, my lord. The concluding part, my lord, as page 26.
And the second order?
Second order, my lord. My lord, page 71.
Date?
Page 71, my lord.
Date.
Yes. The date is 18/8/2017. 18th August 2017.
So you were not reinstated?
No, my lord, till to time.
After setting aside, the order of dismissal was set aside, you are not reinstated.
No, not. And that order is retrospective from 13/2/2014. Dismissed from effect, retrospectively from 13/2/2014.
When is final order passed?
This is the final order, my lord, of the dismissal authority.
Which order?
Page 71, my lord.
18/8/2017.
Yes.
18. So which order was set aside by the High Court?
This order was set aside by the High Court, my lord.
18/8/2017.
Yes, my lord.
Then?
Then remanded matter back to the authority, my lord.
Yes.
To this defense witness test, my lord. Defense witnesses, with finding that the petitioner was not given an opportunity to defend.
So this 18/8/2017 order was set aside?
Yes, my lord.
Was set aside on 31/10/2022.
Yes.
In WPC OSC number 3857
Yes, my lord.
of 17.
Yes, madam. That is page 85 of. Page 85 of that.
Page
85. The order starts from page 85.
That is 31/10/2022.
And the concluding part. Concluding part is page 101.
If you set aside the order, then what will happen? Your dismissal shall be restored.
No, my lord. My point is, my lord.
Yes.
This, my lord,
Your order of dismissal was set aside.
set aside, my lord. But I am.
If you set aside that order, then what will happen?
No, I am on the point, my lord. Once the matter is remitted back to the dismissal authority, the honorable court should direct that I should be, at least that period till the end conclusion, I should be treated as placed on suspension, and so it should be given substantial allowance for enabling to at least contest the.
So did you make this take this stand before the writ court?
Yes, madam. I have taken the stand before the report, and my lordship permits I can give 2 sets of judgments, my lord.
You are just tell us whether you had taken this point or not.
Yes, madam.
Where?
The writ court, my lord, has given. In writ appeal also, I have given both. Paragraph 22, page 8 of the writ appeal, my lord. Page 8 of the writ appeal.
Paragraph 22 of
This writ appeal, my lord. Appeal memo.
Appeal memo.
Yes, ma'am.
Our question was different. Did you take this plea before the writ court that you ought to have been given your subsistence allowance, you should have been reinstated in service after the order of dismissal was certified? Please.
Yes, ma'am. I had taken that plea before the, and after this honorable court, my lord, division bench, while deciding the earlier writ petition, my lord, by the order dated in the page 41 of the writ appeal, my lord, this honorable court also had directed, page 41, I had filed a review petition claiming substantial allowance to treat the period of suspension, to treat this period of suspension and for payment of allowance, my lord. And that review petition, this honorable court directed to decide as per the Police Manual Rule 841.
Stated.
Not to be reinstated, my lord. Dismissal order set as if the court tribunal finds that the furnishing of the report would have made a difference to the
This is what
result.
we are saying.
My lord.
This is what we are saying.
Yes, my lord. I'm reading, my lord. Court resolved in the case that it should set aside the order of punishment, where after following the above procedure, the court tribunal set aside the order of punishment. The proper relief that should be granted is to direct reinstatement of the employee with liberty to the authority management to proceed with the inquiry by placing the employee under suspension and continuing the inquiry from the stage of furnishing the report.
This is what I observed.
Yes, ma'am.
That without reinstatement, where is the question of suspension? A dismissed employee cannot be placed under suspension.
No, my lord. Since they have remanded the proper, that is the proper procedure, my lord. They should place me on suspension, my lord.
Proper procedure, the order was passed when? On, please come to 6.24 of your original application.
Yes, my lord. Or the order was passed, my lord.
You could have challenged this order. You accepted that order.
I have challenged that order, my lord. That order, when in the I filed another second writ petition against which the order was passed, my lord. In writ petition number WPC OAC 3857, I challenged that order, my lord.
I don't understand what happened. Let us see.
32/2014.
First order is 3/9/2015.
23/9. Not
First order is 3/9 to the page 18. That is first. That was the
23/9, sir, not 3/9.
sorry, page 18, my lord.
Page 18.
23/9.
2015.
23/9. Sorry. At page 26, the first order, this honorable court directed to reinstated with full packages, my lord. This one was set aside, my lord.
This order was set aside.
This order was set aside by this honorable court, my lord.
Where is that?
That no, page 28, my lord. Sorry, my lord. Not page 20. Page 28.
Yes. Page 28.
Yes,
This
page 20.
division bench list.
Yes, my lord.
Of this
Page
court.
28, my lord.
One
as page 38, my lord. Third paragraph of page 38, my lord. According to our conscious view, the present case is not coming under the parameters of the exception of the certification of position, and hence the part of order by which the tribunal has directed reinstate of the applicant opposite party seems to be not sustainable, and accordingly the same is not sustainable, and in the result the same is set aside. In the result, disciplinary authority is
But this
directed.
part you have accepted.
For this all court. And regarding payment, once
No, no, have you accepted this?
I have not accepted, I have,
According to our conscious view,
yes, ma'am.
the present case is not coming under the parameters of the exception to the settled position, and hence the part of the order of by which the tribunal has directed to reinstate.
Yes, ma'am. That part, so once directed, dismissal is set aside, and without, you'll say direct, this also directed for another inquiry, without initiating me, for what I'm entitled to get for substance allowance, I challenged, I filed the review petition, my lord. In the review order, my lord, page 41, in the review application, this Anuko directed to deal as per 841, my lord. 841, the payment should be guided as per Rule 89 to 93A of the Orissa Service Code.
Sir, the difficulty is that division bench in no uncertain terms held that you should not be reinstated.
Yes, ma'am. I agree.
And to that extent, the order of the tribunal was set aside.
Yes, ma'am. Yes, I.
Now, in review application, the division bench says that 841A should also be kept in mind. Where is the question of 841 being kept in mind if you are not required to be reinstated in service?
The proper course, this Constitution bench of the Supreme Court says, in such events where there is no provision, my lord.
Is this your case that the earlier division bench decision is incorrect in view of the Supreme Court decision?
This decision,
they should, while remanding the matter, my lord, after dismissal, let not set aside and remanded, the proper course I should be placed under suspension. That is the course decided by the Supreme Court, my lord. That is the
Then
proper.
you cannot be placed under suspension unless you are.
Treated. I should be treated as suspension. Treated. The period. The
There
period
is
should
the
be.
question of being treated as under suspension. When the revisional bench says that you shall not be reinstated,
Yes, my lord. I shall not be reinstated.
then
That period should be treated as, I shall be, but that period should be treated as suspension, my lord. That is my view, my lord, as per the Supreme Court decision, my lord.
maybe we'll see.
And second part, my lord.
So what happened now? What happened? You have again been dismissed.
I am dismissed from retrospectively from 2014, my lord.
Alright.
That they cannot do it, my lord.
Retrospective, you have been dismissed because the court did not directed that you should not be reinstated. Therefore, dismissal is from that date.
No, that order, the first dismissal order was set aside, my lord. That order, first dismissal order was passed in 2014. That order was set aside by and second order after proceeding, my lord.
Sir, the court also observed
Yes.
that your reinstatement shall be subject to final outcome of the disciplinary proceeding.
Yes.
So that was subject to, and finally you were again dismissed. Therefore, there was no question of your reinstatement.
And second,
So what do you want? How are you challenging the present order? On what ground?
first ground substantial. Second ground, my lord, in the after remanding also, the entire proceeding was initiated on the basis of a report of the principal of the college, my lord, training school, my lord. Principal has never been examined, my lord. Has never been examined, and the entire prosecution case fell there, my lord. Second, my lord, there are allegations I scolded in field language to my co-employee. And during course of inquiry, my lord, the victim himself was examined. He refused, my lord. He scolded, and I was persuaded, pressurized to give the complaint.
So according to you, the finding is perverse based on no evidence.
No evidence, man.
This is your submission.
Yes, ma'am. And since the person principal who gave the complaint, my lord, he has never been examined.
That stand was not there before the writ court.
Yes, ma'am. That stand was there, ma'am. Writ court also that stand was there.
Which paragraph?
Yes, state.
Sequentially, my learned senior, the minors have ultimately have found that sequentially how the first tribunal order, then the order was challenged by the state, where minors have categorically held that no, you won't be reinstated. A review was preferred, and also no direct order was. Minors didn't pass any positive order in that review. Now, my lord, pursuant to this or the direction of this honorable court, the inquiry was conducted, and I will not take my lord to the merits because in other cases also I have heard my lord's mind. Serious status, I will not take my lords to that. The question, my lord, is a probation. During probation, hits one of his colleagues with the rifle butt, and he was dismissed. Now, my lord, may kindly see, after the order of this honorable court, we have sent him 3 notices. What this honorable court directed? This honorable court directed, we take you back to the defense stage, you give your defense witness, and the inquiry be completed. My lord, we gave him 3 notices. And each time he says, no, I have filed writ appeal, I will not answer you. By this time, the inquiry would have been completed.
The inquiry is still pending.
Yes, because he's not cooperating. He's saying that writ appeal is pending. My writ appeal is pending. I will not answer you. I have annexed those. And my lord, when this honorable court in no uncertain terms.
No, but where is the order of the learned single judge?
My lord. That in the writ appeal it has been annexed, my lord.
It starts from page 85. The concluding part, my lord, from page 101.
If my lords have page 101.
One is there. Yes.
My lord, sir, page 101.
Yes.
My lord, para 27 I am reading.
Yes.
Since this court finds that the petitioner has not been given reasonable opportunity with a copy to the opposite part number 4 within a period of 15 days from the date of receipt of this order, it is further observed that on such receipt of the list of witness opposite part number 4 shall direct the inquiry officer to allow the petitioner to examine the witness and to proceed thereafter. This court directs opposite part number 4 to take step for appointment of a fresh inquiry officer if the inquiry officer who was appointed earlier is not available. My lord, accordingly, we asked him, please provide your witness list. 3 letters we have issued, my lord.
No, I have given my representation saying I am the sole witness.
And,
there is no other witness for me.
And my lord, may kindly see. My lords, the honorable single judge has come to this, my lord. The relevant para, my lord, it is there. Because we gave a letter asking him for his witness, there was a gap of 7 days. So this on the and it was sent by post 2 days thereafter. So, my lord, we accept, my lord, the findings of the honorable single judge that yes, maybe that he could not get proper opportunity. And my lord, we wanted to proceed from there. And by this time, my lord, this order, my lord, has seen this order is, my lord, 31/10/2022. We're on now, my lord, March 24. The inquiry would have been over, my lord.
I have submitted representation saying I am the sole witness, there is no witness for me. And second ground I have taken in that representation, my lord, this honorable court, in the first order, my lord, directed to conclude at page 38, my lord. That order was passed by this honorable court. On
see, someone is there to spoil the appellant's case. We don't know who. Right from the very beginning. So at this stage, even if we try to help him out, we find it, we feel helpless because of unnecessary litigations and if you want, you can pursue your face the disciplinary proceeding. Otherwise, you have.
Yes, I will pursue, my lord. I will pursue.
Pursue, withdraw the appeal. Or if you want our order, we get. I
will pursue the appeal. Yes.
Learned counsel appearing on behalf of the appellant after extensive arguments has submits that he shall withdraw this appeal with a appeal and shall pursue his case before the inquiring officer and the disciplinary authority.
Let the inquiry officer give a notice so that I will appear. Let him.
So the the appellant shall be at liberty to let the appellant appear before the inquiring authority on when will he appear?
10 days time, my lord.
10 days.
10, 12.
The time, the date, when the office is open. Or stop. In the meanwhile,
On 27th, I'll appear.
27. Okay. Yes.
Obliged.
Item 31.
May I please, Your Lordship? Annexure 3, page 69, Your Lordship.
Annexure.
Annexure 3, page 69, Your Lordship. The order of the single judge is under challenge, where the writ application of the petition was dismissed, Your Lordship.
Yes.
Here the issue involved, Your Lordship, whether the petitioner is entitled to get the horizontal reservation category in the category of PWD, locomotor disability, Your Lordship. Your Lordship, kindly have a glance on the fact remains, Your Lordship, page 30 for the advertisement issued by the OPSC to fill up the post of additional PPO, Your Lordship, Assistant Public Prosecutor, page 34, Your Lordship. The total post was 46. The advertisement, page 34, Your Lordship.
So notices have not been served upon the respondents.
Lords, I'm appearing OP9, your lords.
Only 9.
Yes.
And what about others? 5, 7, 8, 15, 16, 18. 6. Who is the 5, 7, 8, 15, 16, 18?
My lord, may kindly see the order dated 16/11/23.
16/11/23. Refugees filed late be accepted. Office is to proceed accordingly.
Issued, Your Lordship, notice in compliance of.
You have taken fresh steps.
No, my Lord.
16/11/23.
On that day, Lordship, before that already requisite filed, but
Requisite
kept late.
filed.
In compliance, the order passed by the Honorable Court, notice was issued, Your Lordship.
Then after 16/11/2023 order,
My Lord.
have you seen the docket note? Today's
Yes, some notices were it.
upon whom
My Lord.
upon whom the notices were not yet served. Have you marked it?
No.
How many persons are left out?
My Lord, I'll.
Mr. Palit, you are appearing for one. Six.
OP6. I'm one of them. OP6.
For respondent number 39.
39.
30. I am appearing for OP9, your lords.
9.
Yes.
So 3. So rest many are left out.
Total 40.
State is there and I am for OPS. So
OPS.
1 to 3. 1 to 3 were there.
1, 2, 3, 6, 39.
So how we ensure service of notice upon others?
So that it return some.
Yes, your addresses come to respond number 10. Come to respond number 10. What is the address?
The receipt. The noting of the lordship on admission matter, respondent 4 to 49 by RP
What
with
is the
AD.
address given in your application, in your memo of appeal of respond number 10?
The permanent address of the candidate lordship
Those
of
who have refused, we can accept.
my lord.
Those who have, for those we have furnished insufficient address, what will you do?
The address mentioned.
And respondent 25, you don't know.
The address lordship given after obtaining from the OPSC, during REIT application lordship.
They have been appointed.
Yes, lordship.
All of them have been appointed.
Yes, lordship.
Where?
Different courts of the state lordship.
Different courts.
Different courts. The assistant public prosecutor lordship. Prosecutor, they are functioning in different subordinate court of the state
Under
lordship.
which department?
Law department lordship.
Law department. So
Right.
they can ensure that the notices are served upon them.
No, that is not law department. That is home department.
All at
Yes.
whichever department.
State can.
Whichever department. That can be done. Learned counsel for the learned counsel for the petitioner. Appellate based on the office note. Inform this court as to how many respondents have not appeared despite the and upon how many respondents notices have not been served. For the said purpose, let's this matter on 1 week. So tell us.
Yes, sir. Yes, sir.
And this is what we are going to do. Mr. Mishra, we will ask him to serve, say, if there are 20 persons, 20 writ appeals, copies
Yes.
of the memo appeals will be served upon you. And it will be served upon them through Ministry of Department of Justice.
Next.
Complete address would be good.
OPC will be there, but they are under the control of the department. So
The direction was given by through the court lordship to OPSC to produce the address of all the applicants.
forget,
Thereafter, I got that and
forget.
yes, Lord.
Since they are under their control.
Yes, Lord. Next week, I need a lordship and call the matter. I will oblige, Lord.
Item 32.
My lord, item 32, my lord, the petitioner requested me because he is in some other court to seek for a adjournment for 10 days.
Yes, comment, sir.
No, he's for the opposite
I am
part.
for the contesting respondent.
I am for the government, man. I am for the state.
When does he want?
10 days after he was requesting.
As your lordship pleaded.
I was requested on behalf of the appellant.
My lord,
Appellant said this matter on 2 weeks.
Item 33.
May I please, madam?
Yes.
My lord, the appellant has filed this appeal challenging the order of the Honorable Single Judge who has dismissed the writ petition on the ground of a purported concession made before the appellate authority, where the direction to regularize the construction that has been made by the present respondent was challenged. Now, the background of the case is like this. With your lordship's kind permission, may I place the chronology of dates and events I have
Where is the
enclosed?
order?
Now, the order is at page my lord, page 55, your lordship. Page 55.
Yes.
That commences from page 57. May I place it, ma'am?
Yes.
The writ petition involves the appellate order under the provisions of Orissa Development Authority Act, further at the instance of Development Authority being the petitioner herein. Factual background involved herein being defeated by the 91(1) of the Orissa Development Authority Act and appeal being preferred, it appears there has been providing of opportunity to the parties in contest, including the petitioner. In course of hearing, attention has been drawn to the third paragraph at page 34 of the brief, which reads as follows. Petitioner has submitted application for regularization of the structure under Sabakhyama Yojana. The advocate for the BEDA, that is Barampur Development Authority, the present appellant, Barampur, submitted that provisions for parking space has been made and thus illegal structure can be regularized under Sabakhyama scheme. Through the above, it is submitted that the outcome in the appeal proceeding has already involved hearing of the learned counsel for Barampur Development Authority, who has considered the case on behalf of hearing that the parking space has already been arranged by in regularizing the illegal structure involved.
So what is
Under
the
the-
dispute about?
Permission, if I'm placing only the few dates I have mentioned at the beginning of the appeal memo, my lord, that will show that he applied for construction of a commercial complex of B+3.
You?
The respondent, your lordship.
No, respondent.
The respondent applied for construction of a B+3 storage building having my lord, area of 88.32 square meter. Now he made construction, this is a commercial building. So regulation will govern so far as the commercial building is concerned. He makes a construction of a B+4 storage building having area of 166.73. The deviation is 104%. Now he applies, he did not keep a parking space which is required. He did not keep a stair which is required for fire safety purpose. He didn't have any, he had encroached upon the government land in the frontage and also the DT property in the side. Now therefore, the application that was rejected, my lord, so far as the approval is concerned. Now he prefers an appeal. In appeal also, your lordship, if your lordship will, I will place the entire order that will indicate that there has been in fact no concession. It can at best be said to be a submission. And even assuming there has been a concession by the council, if it is contrary to the regulation, that will have no binding effect so far as the appellant is concerned. Because if at all it has to be considered as a concession, then that is contrary to the regulations, which I have annexed, I will show to your lordship. So in that context, so that was challenged in the writ petition.
So what was the regulation?
Regulation, your lordship will see with regard to this not having the parking space and how it has been directed to be regularized. He says he has taken a parking space on rent by the side, but that will never regularize the building, your lordship will kindly consider. But that may go any day. So on a presupposition that that will exist for ever, a regulation cannot be ordered because the building itself should have a parking space. And the safety measures and everything is there in the regulation for the region, but this is a commercial complex. This is not a private building. So I'll assist your lordship with reference
Someone
to
is appearing for the other side.
my friend is there for the
I am
other
appearing for
side,
this matter 2 and
private
3,
opposite party, madam. He is there, madam. With your lordship's permission, may I place it from page 2? The appeal memo, my lord, the chronology of events, your lordship will kindly see. Then I will place the order of the appellate authority and thereafter your lordship has been pleased to peruse the order of the Honorable Single Judge. And your Lordship will consider whether there can be at all the statement that was submission that was made for the appellate authority can be termed as a concession, number one, even as to
That part of the order.
that part of the order of the appellate authority, your Lordship.
Yes.
My, that your Lordship will kindly find at page 29, your Lordship. It commences from page 29.
Yes.
And the purported concession finds place at page page 34, your Lordship. Page 34, your Lordship.
Yes.
The third para, the petitioner has submitted an application for regularization of the structure under Sabyakhama Yojana. The advocate for the Beda, Barampur, submitted that provision for parking space has been made and thus the illegal structure can be regularized under Sabyakhama scheme. This is what has formed the basis before the Honorable Single Judge to dismiss the writ petition and direct that this should be a one-time measure. It is not a question of one-time measure regularization.
So what is this Sabyakhama scheme?
Sabyakhama scheme, your Lordship will see that I have annexed, that your Lordship will kindly see. Page 37.
Yes, so according to you,
My,
it was not a concession, it was a submission that it can be regularized, but under that scheme.
and not only that, your Lordship, I beg to submit if the preceding notings that have been made by the appellate authority would be perused in toto, then it is not at all a concession also.
No, this itself is not a concession.
Much obliged, ma'am.
If he says that the illegal structure can be regularized,
Exactly.
all right,
Ma'am.
but under the scheme.
Much obliged.
So this is subject to the scheme.
Much obliged.
Regularization is subject to the scheme.
Ma'am.
This is not a concession. This is a
Respectful,
submission.
madam.
This is-
And but the Honorable Single Judge takes it as a concession and the disposal of the writ petition is solely on the basis of that, your Lordship will see. Nothing else.
We will hear.
Madam.
Yes.
Beg apology for mentioning this matter at this hour. There is a single bench assignment of your lordships under arbitration where your lordships have reserved a judgment on the question of 29A.
Yes.
Under 2-1.
You come.
But I beg extreme apology. Today, it has come to my notice that there are two contradictory judgments of this honor.
And the Supreme Court, all right.
So
Later.
if that is coming up tomorrow,
Give it tomorrow.
I'll
Give it tomorrow.
Great.
Item number 37. Lordship, I will taken up next week.
37, all right.
Well, item 37, my lord. My second item, my secretary, I'm ready for item 37, second.
So he is seeking adjournment.
My lord,
Two matters, there are two matters.
All right, we will take up tomorrow.
Pardon my lord, one tied up matter anticipable, file
Give
6
the
months.
slip to the Deputy Registrar Judicial.
I filed several memo that is tied
When
up
did you
to
file?
that filed minimum 5 to 6 memo
When?
before
when was
PTR
the
and
last
honorable Justice B.R.
When
Sarangi.
was when did you file your last slip?
7 days back before the court, honorable Justice B.R. Sarangi.
Give the slip to the Deputy Registrar Judicial.
Item 43, I want next week any date. Because of my
Tomorrow.
All right, tomorrow.
because I have some
We'll see
throat infection, that's why.
For the last.
All right,
We'll see you tomorrow. Thank you.